May I please, Your Lordship, may I mention item number 22?
Item?
Item number 22, my lord.
Hmm?
Item number 22, my lord.
Yes.
Here, my lord, I am for the CBI, my lord. And my lord, the CBI has sent me the copy of the affidavit, which is found to be defect, my lord. So therefore, some more time may be granted to file, my lord, affidavit, my lord.
I am for the petitioner.
For the petitioner. Mr. Madhav Gato, SC, CBI. Praise for father. How much time?
3 weeks time may be granted.
3 weeks.
Right.
Father, 3 weeks time to file affidavit on behalf of the respondent. To which, oh, sir, just a minute. Huh? Miss,
And only.
okay. The prayer is allowed. This matter after 3 weeks. Miss,
Development.
Interim to be continued, Your Lordship.
Miss, her name is also present on staff. Para. The interim order passed earlier shall continue till the next date. Okay.
Development.
May I please, my lord?
Yes.
My lord, I beg to mention item number 9, my lord.
Item 9.
Yes, my lord. My lord, I may be allowed to withdraw this bail petition, my lord, with liberty, my lord.
Mr.
M. Doji, my lord.
M.
Doji, my lord.
Doji, Land Council 4. The petitioner wants to withdraw this bail application with liberty to file a press.
Yes, my lord. Since, my lord, I have to annex some medical documents, my lord.
Okay, the prayer is allowed. This bail application is dismissed on being withdrawn with liberty as prayed for. Okay.
Obliged.
May it be pleased, Your Lordship. Your Lordship, I beg to mention item number 20. I'm for the petitioner, Your Lordship, and according to the last order, we're supposed to take steps, but due to unavoidable situation, we could not make it. So I may be allowed to take a fresh step again, Your Lordship.
Against? Respondent number?
Only one respondent, Your
Okay.
Yeah.
Miss
B. Mema.
Land Council 4, the petitioner submits praise for father submits that she could not take steps upon the respondent and prays for some more time to take steps upon the sole respondent. The prayer is allowed. Step be taken within a week from today.
Yes, Your-
Release this matter after 3 weeks. Okay.
Obliged, Your Lordship.
Yeah, Your Lordship. I beg to mention item number 6. The council, leading council is out of session, Your Lordship. I'm for the petitioner. Maybe release after 2 weeks, Your Lordship.
Whether you have informed the other side,
Yes, Lordship.
whether we have you informed the other side?
Yes, I have taken the consent from other side.
Okay. Miss
Tirimi.
Land Council for the petitioner. Your name is also there.
Yes, my name is also there.
Okay. With the consent of the other side. Praise for listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Obliged.
Lordship, I beg to mention item number 9.
9 already mentioned.
Huh?
Someone mentioned.
Okay.
Bail application withdrawn. You are in the bail application as a petitioner?
Item number 7, Lordship. I'm for the petitioner side. And my
What-
senior item number 7. Item number 7. Double PC number 58. Lordship.
Yes.
Ah,
CRP,
yes.
criminal petition,
Yes.
58. Okay.
The matter may be kindly fixed for 6 December.
Why?
Because, senior counsel, he cannot appear today because due to some health issues.
Oh, you are for the petitioner.
Yes.
Miss Panam Harilung. Miss
Dirilo.
Land Council. So, Land Advocate submits that uh, sorry, the conducting council, who has some difficulties, you said?
Senior counsel, sir.
Who is?
A.K. Prakasto.
Okay. Our senior counsel, A.K.
Prakasto.
Procasto, has some personal difficulties today due to which he could not appear and prays for adjournment of the matter. And request for fixing this matter on
6th December.
6th December.
Yes.
You are for
I'm for the private respondent.
private respondent, to which the land counsel for the respondent, Mr.
The other.
has no objection. So prayer allowed. List this matter on 6th November.
6th December.
6th
December.
Okay.
Masal.
Lordship, I like to mention item number 4.
Yes.
Yes, item number 4. Matter may be taken up after 3 weeks, Lordship.
Why?
We have taken consent from the respondent.
Why after 2 weeks?
Lordship. Leading counsel is having some difficulty.
You are Mr.
Yes, Your Lordship.
Learned advocate, submits that the leading counsel has some difficulties today and prays for listing this matter after
3 weeks, Lordship.
3 weeks. He has also consent from the other side. The prayer is allowed. List this matter after 3 weeks.
And Lordship, item number 24.
Item 24.
Yes.
What do you want?
This may be also taken up after 3 weeks.
Same prayer. You are for the,
I'm for the
Appellant.
respondent.
have you informed? Where is the
Yes.
petitioner?
I have informed the petitioner.
Inform the
Yes, we
petitioner.
have taken the consent.
Okay, Mr.
Yes, Your Honor.
With the consent of the land counsel for the petition, appellant, prays for listing this matter after 3 weeks.
Yes.
The prayer is allowed. List this matter after 3 weeks.
And your evidence.
Okay.
Lordship, I beg to mention item 23. 23.
Yes.
Today it was for hearing on IA,
Yes.
but we need some more time in this matter. I am for the petitioner. We have taken the consent of the other party. The matter may kindly be fixed on 3 December specific date. That's it.
You are Mr.
A. Gamre, on behalf of V. Jamo.
On behalf of
V. Jamo.
the
V. Jamo.
Jamo. You are for respondent.
Petitioner.
Jamo, okay, Jamo is also there. Appearing on behalf of V. Jamo and with the consent of the. This is criminal appeal only.
Yes.
The other side prays for listing this matter. After
On 3 December.
on 3rd December. Have you informed the other side?
Yes,
That's
yes.
6 for
Yes.
3rd December. The prayer is allowed. List this matter on 3rd. 3/12/2024. Okay.
And also Lordship, item number 26.
26.
Yes.
Yes, what you want?
In this matter, we have taken the consent from the other party to make it listed on 16th December. Lordship.
6th December,
16th,
16th.
yes.
Why 16th?
Because it will be convenient for both the leading counsel in the matter. Due to some issues with
You are for the petitioner, yes?
petitioner.
Mr. Again.
A. Gamre.
Here also you are appearing on behalf of Mr. V. Jamo.
Yes, yes.
Appearing on behalf of Mr. V. Jamo, land counsel for the petitioner. Prays for listing this matter on 16th December. He has a consent. He has obtained consent from the other side. In view of the above, the prayer is allowed. List this matter on 16th December. Okay.
My lord, I beg to mention item number 17 and 18. On behalf of Mr. Tabatupu, the leading counsel, he is having ill health, so this matter may This, both the metro may list after 2 weeks,
17 and
18.
we'll have to see what is the stage. Wait for some time. Okay,
All right,
let us see the file.
obliged.
Your Lordship,
Yeah.
I would like to mention item number 14. This is a criminal appeal. On behalf of the appellant, I am the LSC counsel. I concern took the from the other side, PP. And in context of this case here, my lord, the respondent to till the notice not served. So give 2 weeks time for they appear also I prepare, Your Honor, my lord.
You are for,
LSC on behalf of the appellant,
on behalf of the appellant.
LSC. Item number 14,
Oh, sorry, 14.
14, 1 4, my lord.
Okay.
M. Nagra.
When do you want to say?
2 weeks time, my lord. List of this matter.
The
12 weeks.
respondent hasn't received the,
Respondent number 2 is not receive any copy, the notice of the victim. One is the state of Arunachal Pradesh, the PP. The second one is victim. So respondent number 2 is not received the service of notice, my lord.
wait for some time, let us see the record. What it is reported, office, let us see the office note. Okay.
Okay.
Mm.
Much obliged.
Yes.
Look, this civil litigation has been, but again, the implement of the decision 3/10/2024 passed by the Lamet Civil Senior Judge Patigar, in case number 23 of 24 and 24 of 24. In civil appeal number 68 of 2023. My lord, here the petitioner is the respondent in the civil appeal number 60 of 2023, which is pending before the civil judge Senior Judge Patigar, and the respondent is the appellant. My lord, what happened? The petitioner clear his affidavit in reply from objection on 13 June 2020.
Affidavit in reply.
Affidavit. It's an objection.
Okay.
On 13/6/2023, before the solicitor of the CJM court. And same was registered as CJM documents number 140 of 2023. But the same was not placed before the record. And as per the order dated 2011-2023, passed in IN number 15 of 2023. My lord, kindly page number 69. 92 is the relevant portion.
Six nine.
Yes, madam.
This is written statement.
No, relevant portion. Item number, page number 34.
34.
34. Can you see paragraph 26?
Yes.
Before 26, paragraph 25. Accordingly, IN number 1523 is rejected and disposed of. The case will be proceeded for hearing in the original appeal. The respondent is directed to file his reply slash objection on or before the next date. The next date was fixed on 19/12/2023. Well, after that, what happened? A case was fixed on 19/12/2023. There was a meeting of East Siang District Bar Association regarding the conduct of the sports meet. Minutes of meeting at page number 35.
Yes.
Wherein my lord, they have decided to conduct sports meet from 18 to 22 of December 2023.
Whether the minute also decided not to file any reply.
No, my, this is the minutes of meeting.
Huh.
And my lord, accordingly, the Bar Association had submitted a representation to the CJM court as well as the district court of Patigar. Now, kindly ferrous that page number 36.
Yes.
Then, well, request for consideration the absence of Asian
Okay.
District Bar Association from court due to sports meet of Bar Association effect from 18/12/2023 to 23/12/2023. Accordingly, my lord, it was in the anticipation of the that there was no court on the scheduled date. So the counsel for the respondent was not appeared before the court. And
How
reply-
that order can be
reply was-
passed? No.
reply was
Where is that order?
my lord, this order at page number 44.
44. Who passed that order?
The counsel for the respondent was not appeared. However, matter was discussed.
Yes.
Yes, my lord,
So
here,
this is order only.
yes, my lord,
Order in the court
here, my lord,
reflecting the absence and presence of the counsel.
yes, my lord, here, my lord, on this date, the respondent was supposed to file his objection.
Hmm.
But he was under the impression that there was no court on this day. Because
Whether there is a court or no, no one prevents you from filing reply on time.
yes, my lord, here, my lord, on that day, there is a,
It's not that you have to file the reply or objection before the court. It has to be filed before the office only.
yes, my lord, already I had filed on 13 June 2023. Yes, my objection was registered. My
Has
lord,
it reached June?
yes, my lord, kindly see page number 69.
What is that?
Page number 69.
Hmm.
We have already, objection has been already registered as PGM document number 140 of 2023.
This is the written statement
Yes,
already filed.
yes,
Then what happened?
already registered, but this objection was not placed before a record on.
What do you mean? You have filed or not?
Yes, I have, this objection was swear and registered before the registrar. But
Okay.
same was not filed in the record, placed in the record.
Why?
Record of the case.
Why?
Because my lord, in CGM court, when we file objection, we register before the registrar, and this has to be placed on the record during the course of the proceeding.
No. Once you file, means it will be with the office only. You will have to keep it before the office only.
My lord, in CGM court, Pasir,
Why you took back this one without keeping this with the office, with the file?
yes, this has to be, my lord, placed on 19/12/2023.
Why you took back after filing?
My lord, there is in normally in the CGM court, Pasir, they are directed to place the objection only
The
on.
duty of the office
Yes, yes.
to place it before the court as and when the matter is listed. Hmm?
My lord, on the order passed that
After filing, you took it back. What you wanted to do with this written statement thereafter, after filing?
well, after filing this,
It amounts to no filing only. If you had taken back.
madam, I have to place this objection during the course of hearing on 19/12/2023. But on that day, I was absent.
So,
Counsel
so?
for- was absent.
Hmm.
So they pass order. My lord, kindly see that. Page number 44, madam.
Page 44.
44. Last paragraph. For the reason aforesaid, the reply will be no longer accepted. The council make oral submission. My lord, being agreed of this order, the petitioners made a mistake application.
Since the respondent have repeatedly sought time to file a reply, but even then they have failed to do so. Send that on so and so the court has categorically mentioned by counties in no time to that the reply is to be filed within 1 month before the court of this. But even then, after a passage of more than 9 months from the date of the said order, the respondent has failed to take steps. Then
My lord,
this is the impugn order. Is this the impugn order?
no, my lord, impugn order is as page number 63.
Page
63.
straight.
Yes, my lord. Here, my lord, I have the petitioner has filed two mistakes application. One for condonation of delay of 55 days, and another for allowing him to file his objection.
Yes.
But
So what is wrong in it?
But the learned civil justice senior division has rejected the condonation application.
So what is wrong in it?
Because my lord, here, my lord, the counsel for the petitioner has properly explained the cause of delay.
What was the cause of delay?
My lord, there was a district sports meet.
That is not connected. That is, say, hardly 1 week. But then no one prevents you to file affidavit on time.
My lord, this is this is a fault of the council and this council. My lord,
Yes.
my lord, there is a second loaded and the TN should not be suffer because of the fault of the council.
Why?
But already here, the petitioner has shared his affidavit in 13 June 2023.
Affidavit?
Yes,
You have not filed on a council. You have not filed, it appears.
but already they have registered.
Why you have taken that? You have played mischief with the court there.
That is the mistake of the investment.
Not mistake. It was a mischief. Because you took back. You did not keep it. Why you took it back again after filing it before the court?
Because
You wanted to do something with that after filing. Then why did you take it?
madam, this has to be placed before the court within the course of proceeding.
That can't be. It has to be with the file only. It has to be filed with the file and to be placed before the court by the staff only. Like the file used to come before this court. They cannot adopt different rule. How the council can file before the court? Court will not accept. It has to be filed before the registry only. It has to be filed before the office only. The solicitor in the district who will accept and place it before the court. I have never seen.
Madam, that may be the fault of the Indus council.
Then
For that, the petitioner shall not be surprised.
that cannot also be. Because generally every time that the council make mistake, so how can it be?
Without,
That cannot also be. So what do you want by this?
madam, only, madam, my friend is only allowing my objection. Already shared in the one of
No, it has to be on time only. 9 months. Even after 9, giving an opportunity to file objection.
madam, for
Even after 9 months also, after passing the order by the district judge to file objection. Even after elapse of 9 months, you did not file.
In that period, there was one.
And the learning court says that you did not express no interest in trying to find out the nature of the order. Who are the respondent?
No responding.
Okay, any issue, will issue notice? You want notice to be issued?
Yes.
No, but no stay.
Final hearing of the case is for the so is there already?
No, we cannot encourage such lethargic advocates for 9 months, not filed, and then now you are taking 1 week, sports week.
Madam, in that period,
And pardon, Mr. You are Mr.
Omodi.
Foreign Modi, Modi, Learning Council for the petitioner. This is an application under Article 227 of the Constitution of India. Okay, by filing this civil revision under Article 227 of the Constitution of India, the petitioner has challenged the order dated and assailed the order dated 3/10/2024 passed by the Learned Civil Judge Senior Division, passed in this case number 23/24 and 24/24 in civil appeal within bracket K, capital K, bracket close, number 68/2023, whereby the petition filed by the petitioner has been rejected. Stop. Issue notice returnable by
1 week.
1 week.
Yes, but I'm available with justice officer.
1 week. This is a Pasigat.
Yes,
Possible. Returnable by 2 weeks. Stop. The petitioner shall take steps upon the respondent by a registered post with AD as well as by usual process. Stop. You want to take by justice service?
Yes.
Okay. The petitioner is also allowed to take steps upon the respondent by a justice service for the registry and to file affidavit to that effect. List this matter after 3 weeks. Okay.
May we please, your lordship?
Yes.
Lordship, the accused has been arrested on 03/10/2024 on the basis of FIR dated 01/02/2023, which was registered as simple PS case number 09/2024 and corresponding GR case 77/24. Your lordship, I have filed a bail application before the lower court JMFC.
Okay.
Lower court JMFC, your lordship, but the bail application has been rejected by the lower court JMFC on 23/10/2024. Your lordship,
Three? When it was rejected, have you annexed the bail rejection order?
no, you're not.
Why?
No, your lordship. It was rejected on 23/10/2023.
Recently?
Yes, your lordship.
Not annexed the
ground
bail
for-
rejection order?
Yes, your lordship, ground for not enclose, the rejection order is your lordship on para 2, your lordship. PTP of the rejection order was applied on that day itself, your lordship, but the concerned staff and the tester unable to furnish the said rejection order. Whenever it was inquired, they said that your lordship, the rejection order was not uploaded.
Which code, which code?
JMFC UPM.
UPM.
Yes. And sometimes they say that the file did not came out from magistrate chamber. As such, they could not
The-
furnish the CTC copy.
Then how do you know that on what ground it was rejected?
Pardon, lordship.
How do you know that it was rejected and on what ground?
Ground ground was that the investigation is going on. And investigation is going on and it is in three steps. That is the ground for rejection.
Okay, that was rejected on which date? 23.
Yes, your lordship, 23/10,
Some about
23
10 days back.
10/2024.
So then, what is the ground taken by you before this court for bail? If that was the ground for rejection, what is the new ground you have taken?
Oh, ground is here in para 8, 9, 10.
Okay, what is para 8 and 9?
Your lordship, as per your lordship, the nature of allegations is of civil nature because breach of all contractual conditions is not an offense unless the element of dishonesty and inducement is made out against it. In this case, your lordship, the accused has already repaid the 83 lakhs out of 92 lakhs. He has already repaid the 83 lakhs out of 92 lakhs, your lordship.
After commission of offense, even if you repair also, it won't help you. Okay, anyway, so what do we do?
Your lordship may call for the case diary, your lordship, it's a PA application.
But it was rejected recently only.
Yes, meanwhile, they can bring out the, if they get the certified copy of the rejection order, they can annex this later on, your lordship.
Okay. Hard Mr. Land Council for application. This is an application under filed under section 439 of the Criminal Procedure Code, 1973. Okay. We'll make it section 483 of BNS. The corresponding section of 483 of BNS 2023. Paying for ground of bail to the accused. What is the name of the accused?
Dheeraj Pao.
Hmm?
Dheeraj Pao.
Dheeraj Pao, who has been arrested and in connection with where have you mentioned the PS case number 9/2024 under section 420 IPC. Para. Issue notice, call for the case diary. Now, scan copy of the case diary. Miss. Okay. The additional people has accepted notice on behalf of the state respondent. No formal notice need be issued. Okay, start now. Please this matter.
On 13th, your lordship.
30 days.
Not possible, your lordship, on 13th.
13,
Please.
on 13, okay.
Deeply.
This is in petitions. For alteration modification of bail order passed by the Senate on 4th October 2024. Lordship may kindly go to page number 17. That is the portion which has been paid for alteration.
Yes,
Page number 17, para 11. Lordship, here the bail bond was set at 20,000 with two surety of.
not said at local surety, but it said a resident of Arunachal, whosoever may be. Resident of Arunachal, it says, whosoever may be,
Yes.
only resident of Arunachal, because he is from outside.
That is the lordship. Arunachal Pradesh, resident of Arunachal Pradesh. will be-
Anywhere, wherever it may, he may be.
Lordship, he is
But then he is from Assam, it's very
Yes.
difficult, from outside state.
from Assam and
That has been trouble in the trial court, never to find them again. Very difficult.
he is willing to produce a surety with a landed property in Assam. Because he is a resident of Assam and he doesn't have any acquaintance or relative in Arunachal Pradesh, so it's really tough to secure a surety.
No, anyone, you see, who should be resident of Arunachal, whosoever may be.
It does not refer to
Tribal,
local.
non-tribal,
Yes.
whosoever may be.
Whosoever.
It's only the condition, because it's, what is the offense? NDPS. What is the offense? 302.
Murder.
Then it's difficult. It's very difficult. We've been in a trial court, very difficult to find.
Yes.
But since he is unable to secure a resident of Arunachal Pradesh, as well,
The-
they are a permanent resident of Assam. If lordship gives condition where the surety can be of Assam. with
He
the-
came in Arunachal and committed the offense. He must be having,
If he was a labor worker, he was brought from Assam to work.
then that becomes more difficult. That will become.
Lordship, now he is willing to produce a surety who is a resident of Assam with a landed property out there.
If I may take your lordship to page number 5, your lordship, my landed council has in fact misread the condition, your lordship. He has clearly written it's the difficulty of finding a local surety, which
It's
your
not
lordship
local
is.
surety.
Yes. Yes.
Whosoever.
And
may-
there are, it does not need to be even any relative. of-
Only said with the further condition that the accused person shall cooperate. No, no. Which, one of which should be the resident of
Yes.
Arunachal, resident of,
Resi-
anyone.
That may be lordship, but here the problem is he being a resident of Assam is unable to secure a resident of Arunachal Pradesh. That part can, if lordship may kindly to alter.
He worked with his, his contractor or with whom?
He came with the.
There can be.
But lordship, this is a bail matter. Normally people doesn't agree to be a surety to a unknown person or mere acquaintance. If, the surety can be of a resident of Assam with landed property to secure.
If I may, your lordship, even in the main case, your lordship, what has happened that your lordship has allowed him bail only on only on the record that without the learned magistrate, without issuing a bailable warrant, has
Without
issued it.
issuing bailable warrant, he
Has
was arrested,
ah.
issued a non-bailable warrant.
Yes.
Because he did not cooperate, he did
Yes.
not appear before the court. That is why, and this probably is necessary here.
Yes.
But lordship, the bail granted, you know.
Because we have seen him that the moment he was granted bail, on bail only, he did not cooperate from the very first instance.
It's been 1 month since he has been granted bail, but he is unable to secure a resident of Arunachal Pradesh. So the bail granted is.
Now, we can't concede with such, you see, attitude. Because we have seen, the court have seen that he did not cooperate, he did not appear, and because of that only the court has issued non-bailable warrant of arrest against him to secure his presence only.
Yes.
And in.
Now
in-
we
in-
can only, what we can do is to expedite the trial
one of the main condition, why this condition was put up, your lordship, was that he was granted bail in the year of 2018, your lordship, by the magistrates court, your lordship. Even after bail was granted, he did not appear. Therefore, a request was made for a non-bailable warrant, your lordship.
Lordship, even
At page
the
number 13,
bail
your
has
lordship.
granted. Now it's been 1 month he is unable to secure the
Now you see,
security.
now the seriousness, of the allegation
Lordship,
against him,
if
302, if it
allows
is
me-
302,
Yes.
1 month is nothing.
If Lordship allows.
If he is convicted, 1 month is nothing. 1 month, 2 months is nothing. We do not know what he is planning for next.
Lordship, near the surety part where resident, instead of a resident of Arunachal Pradesh, surety with a landed properties, with the landed property.
That is
from Assam.
specific may not be possible.
Yes,
But then this is
but
reasonable, otherwise resident of Arunachal.
Because Lordship,
The surety bail bond is also for 20,000 only.
yes. Otherwise, Lordship is very fair. No issue with the order or the judgment, the bail order granted. It's very fair. But only the portion regarding the resident of Arunachal Pradesh. The same in the Supreme Court in the sumo to writ petition number 04 of 2020.
Whether in such case, the informant is required to be informed? No.
This is regarding the alteration, it's up to the court.
In fact, they ought to have come under, while filing an IA, your lordship, instead of coming under 482, your lordship. IA in the dispose of bail application, because the order under bail application is to be altered, and that application has to be brought into record along with this petition. However, your lordship, even if the technical ground is to be taken aside, your lordship will see when the main case was, the BA was to be considered, your lordship. The first consideration was that he had been not cooperating during the trial, your lordship. He was granted bail in the year 2018. He did not appear before the court, and therefore, instead of first issuing bailable warrant, the court has issued non-bailable warrant, and only on that consideration, this court has granted him the bail.
Whether, by the way, whether the earlier bail was cancelled?
Yes, your lordship. After
Okay, after cancelling.
no, after his arrest, because he did not appear, your lordship, after the violating the bail condition, your lordship, and therefore a request was made for issuing a non-bailable warrant for arrest, your lordship. The court, instead of first issuing bailable warrant, has directly issued non-bailable warrant for arrest. He was thereafter arrested, your lordship, and then they had come before this court for bail. Now this court has only considered that the learned trial court ought to have first issued bailable warrant, and thereafter, if not execution of that bailable warrant, non-bailable warrant ought to have been issued. Only on that technical ground.
Whether the earlier bail granted 2018,
Yes,
whether that bail has been cancelled,
your lordship, after his arrest,
subsequently cancelled.
after his arrest, it automatically goes away, your lordship. After his arrest before this bail was granted, your lordship.
How long he has been?
He's already in custody for almost 300 days.
Now, in the beginning, when he was arrested earlier, at that time, how long he was there inside?
Inside, before the trial started.
Yes.
That lordship I'm looking at.
Lordship.
After his arrest, current arrest, he's already been in custody for almost 300 days.
No, not 300 years. If your lordship will come to page number 16, your lordship. Page number 16, your lordship.
Yes.
After granting bail in the year 7/6/2018, he had not appeared, and he was, paragraph 7, your lordship, he was absconding for 5 years and evading trial. Only on his non-appearance, even the trial has been stopped, your lordship. And then
What is the stage of trial now? How many evidence has been recorded?
we are not.
Lordship, other co-accused were not, they are absconding. Only his part of trial has been commenced. Now it's in evidence.
How many evidence recorded? how many prosecution witnesses have been
Lordship,
examined?
that part was considered during the bail application. Lordship may allow, I will place some judgment.
What is that?
Supreme Court judgment regarding bail.
What it says? That, that's,
Serial number 6 and 7. Point number 6 and 7. So this is a suo motu writ petition criminal 2021, where the guideline was set regarding the
that is,
surety.
that is there.
Yes. May I-
Yes, yes.
If the bail bond are not
That is-
furnished within 1 month from the date of grant bail, the concerned court may suo motu take up the case and consider whether the condition of bail require modification or relaxation. One of the reasons which delays the release of the accused or convict in the instance of upon local surety. It is suggested that such case the court may not impose the condition of local surety. So the principle here is
Yeah, that is there, but here's the case where he defaulted, he did not appear to the court for trial,
That is the-
while trial is going. on.
But Lordship, if this condition of producing a resident of Arunachal Pradesh is there, so we will unable to benefit from the bail granted by this order. Yes, sir. So Lordship, if only one part, instead of a resident of Arunachal Pradesh, a surety with the landed property from Assam, he is willing to produce that.
So,
Yes, I'll leave the discretion to your lordship, because as per my understanding of this suo motu case, your lordship, even the Supreme Court has, while
what is this?
This is also.
this,
regarding-
the Supreme Court has clearly stated that it's the discretion of the court.
Yes, yes.
After 1 month, if he cannot, then
That-
the court will consider if it has to be modified or not. That is there. Now, in this case, your lordship, every case has their own understanding, your lordship. In this case, your lordship has already considered, though your lordship has given bail on the technical ground that was proceeded not accordance to the law, your lordship. However, your lordship will see that he was absconding for 5 years. See, and the only fact that he could not be traced out is because he was he was a resident of another state, your lordship. Now, this also speaks of local surety, your lordship. Whereas your lordship's order, there is no local surety. Now, to proceed with a proceeding on timely basis, your lordship, a court has, while granting bail, has to put certain conditions. Shows that if these conditions are not put, your lordship, he will again skip the proceeding, and your lordship, the case would not proceed accordingly. Otherwise, your lordship, otherwise I leave the discretion to your lordship.
The order, the bail order passed earlier doesn't say about local surety, but it states about resident of Arunachal Pradesh. Then somehow make it a local surety.
No, resident of Arunachal has the
Because
right
he
to
doesn't
vote.
have any-
Does not-
Anyone in the state of Arunachal Pradesh, this state, to secure as a surety. Because he is a permanent resident of Assam, he just came here as a labor and started the commission of offense and then he was arrested.
Heard, Mr.
Yes.
Yeah, sir. Counsel for the petition. I've also heard Mr. Additional additional PP for the state of AP. Start. This is an application filed under section 528 of the Bharatiya Nagrik Suraksha Sanhita. Within the section 482 of the Code of Criminal Procedure. Paying, bracket clause, paying for alteration and modification of bail or the date is 4/10/2024, passed by this court in bail application number 93, 2024. Start. The case of the petitioner is that accused Anand Tanti, who was arrested in connection with. He was the session case number 08, 2019, arising out of seizures of this case number 10, 2017, under section 302, 34. And by an order dated 4/10/2024, this court granted bail to the accused with the direction to and directed to release the accused on bail on execution of the bail bond of rupees 20,000, which two surety of like amount, one of which should be a resident of Arunachal Pradesh, with the further condition that the accused person shall cooperate and appear before the trial court regularly. Start. The planning counsel for the petition submits that the accused is ready to execute a bail bond and furnish landed, what do you say?
Landed property.
Landed property.
Who is surety, who is a landed property.
Surety with the land with landed property at a sum. However, he is unable to produce the surety who is the resident of Arunachal Pradesh. Hence, pray for, and who is resident of Arunachal Pradesh even after expiry of how many days? Even-
1 month. In 1 month.
Even
Since
after
the passing
expiry of about 1 month from the date of passing of the said bail order, hence pray for. Praise for address. And modification of the said bail order, bail said condition in the bail order dated 4/10/2024. Miss Trini Daniel Education PP submits that the accused was arrested. No, accused after obtaining bail was evading trial and remained absconding for about 5 years. Evading trial, huh? evading trial proceeding and remained absconding for about 5 years, due to which the court proceeding could not take place. And since he is from the outsider, he belongs to outside the state of Arunachal Pradesh, there is every possibility that the accused may jump bail and remain absconding. Hence, the condition that one of the surety to be resident of Arunachal Pradesh is a fair and reasonable.
Your lordship may also add to the fact that the given condition, your lordship, does not speaks about permanent or temporary resident.
She further states, she further clarified that as contended by the learned counsel for the petitioner that does not
speaks about permanent or temporary resident.
the said order speaks only about the resident, only about the surety to be only about the surety to be the resident of Arunachal Pradesh and not the permanent,
Not
not the local surety.
not local surety, neither permanent or temporary, your
Either
lordship.
permanent.
Any resident.
Hard for the land council for the parties. Considering that the accused has spent more than 300 days inside a custody after re-arrest, and also considering that even after expiry of 1 month, the accused could not execute a bail bond and produce a produce a surety who is the resident of Arunachal Pradesh. I'm of the consider view that the prayer of the petitioner can be considered.
और bail दिया था
Considered,
24 को। और यहाँ से अभी तक नहीं।
and accordingly, the bail, the accused is directed to be released on execution of a bail bond of rupees 50,000 with two surety of like amount, one of which shall be what you said,
Resident of Assam with
resident, one of which shall be resident of
Assam with the landed property.
okay, shall be with the landed property
Assam.
at Assam.
Yes.
Okay, at Assam. With the further condition that the accused shall cooperate and appear before the trial court regularly. And trial court as and when required. Stop. With the above, the bail order dated 4/10/24 stand modified. Okay, with the above observation, the bail order dated 4/10/2024 stand modified accordingly. So, bail, and this application stands allowed and disposal.
My
Yes,
lordship, this matter may be passed for time limits. Counsel for the respondent, Mr. D. Soki is at court number 1.
okay.
For a time being.
Possible for time being.
Yes, lordship.
Okay.
Okay.
May I please?
Yes,
It's a NDPS case, my lord. And
NDPS.
I am, the quantity is in between. 21.
21B.
Yes, my lord.
Okay,
And I am, behind the person 66 days.
66 days.
My lord.
Okay. The maximum punishment, the
10
statutory period will be 60 days.
Up to 10 years.
Okay, up to 10 years.
Up to 10 years.
Okay.
It's my lord, that's
Whether the case has been charge sheeted?
not yet.
Not yet.
As per my information, my lord, charge sheet was not.
Lordship, may kindly pass over this matter for a time being, Your Lordship. I've just taken instruction whether charge sheet has been filed or not.
Right.
And later on, one more issue is also there, Your Lordship. I will bring it to Your Lordship knowledge, Your Lordship.
Yeah.
Just pass over to get instruction.
For a
whether
time being,
charge sheet is filed or
let him obtain instruction. Okay. Yes. No one appeared on behalf of petitioner on court. The office now dated 4/11/2024 reflects that the service of notice upon the respondent number 2 to 20 is still
Your Lordship,
awaited.
the council is present, Your Lordship.
Okay. Service report.
Extremely
still
sorry,
awaited.
my lord. My lord, on behalf of third respondent, we have taken two steps, press step also taken. So they are well known that this matter is pending before this honorable court. Even they have filed title suit before learned court of civil judge senior division at SEPA in connection with this case, my lord.
So what to do? 2 to 20, report still awaited.
Yes, Your Lordship. 482 mandates service upon the respondents, Your Lordship.
Hmm?
482 mandates service upon
Yes.
respondents, Your Lordship.
Wait for some time.
Yes, my lord, in that case, I may allowed to take dusty service on all the
Dusty?
private respondents, yes,
This criminal petition. Is it
criminal petition.
Yes, Your Lordship. As per my understanding, Your Lordship, Dusty is only in the civil matters, Your Lordship.
Yeah.
But then in this matter, if they can, since they have reflected the police station from where the accused belongs, Your Lordship, steps
This
may
is
be
quashing
taken.
petition.
Yes, Your Lordship.
My lord, this
Yes,
is,
Dusty may-
the petition is crossing for order being passed by the district magistrate, Pakistan, under section 145 of CRPC. Without hearing from the petitioner, yes, district magistrate deputy commissioner has passed an order prohibitory order, my lord. So that was being challenged in this crossing of that order being challenged by the petitioner, my lord. So now this
And
private
who are these respondents? How they are? connected
private
to the case?
respondents, they are claiming my plot of land, my lord.
They were the
The gist of the
complainant.
case is that, my lord, I have a plot of land at Sejo Shaw, Niti Bihar, Darlong. Since 1978, I have plot of land, 24.10 acres of land,
Which place you said?
Sejo Shaw, my lord, Sejo Shaw, Pakistan district.
Okay.
So, my lord, this private respondent, they are claiming my plot of land illegally. And thereafter, they have also filed title suit before the learned court of civil judge senior division at SEPA. And thereafter, again, they have withdrawn. And learned court has also given, my lord, injunction order to maintain status quo. And thereafter, on 13 March 2020, they have withdrawn their title suit, my lord. And thereafter, again, they have filed complaint
So
before.
whether here, in this case, MP, MLAs are involved.
Yes, my lord, there is politically influenced. Since this private respondent, they are engaged by some politically motivated persons who are trying to grabbing my land, my lord. Since 1978, I am in possession of the land, my lord. So I have also established tea gardens within that area.
So my lord,
So when last step was taken by you?
my lord, stay was taken on 7/1/23, my lord. 7/1/23, I have taken steps,
And
all the
second,
private.
second step?
Second step, Lordship, I have to go through the record because I am also the second counsel in the case, my lord, petitioner counsel. Previous counsel has already left the matter, so thereafter I will engage this matter. Now the challenge only, my lord, causing of the order being passed by Deputy Commissioner Pakistan. Without following the legal procedures, he has passed a prohibited order under section 145 CRPC, my lord. So now, my lord, because of pending of this petition, this criminal petition, the civil court matter is also kept pending. The title should they have filed, my lord.
Heard Mr. Ram and Ram, Land Council for the petitioner. And Rama, Land Council for the petitioner. Also Ms. Cheney, Land ADP. In view of the office note dated 4/11/2024, Mr. Ramalana, counsel for the petitioner, praised for allowing him, petitioner submits that this was the second steps taken upon the respondents, and praised for allowing him to take steps upon the upon respondent number 2 to 20 by a justice service. So,
My lord, 2 to 19. One is the state, my lord. The state is already.
sorry,
2 to 19. Yes.
it's 20.
Yes, 20. The state, one is state.
Okay.
So 2
No,
to 19. my lord.
2 to 20.
Yes, 2 to 20. Yes.
By a dusty mode for the registry.
Your lordship, if I may, your lordship, if the step is taken to the office of the PP, your lordship, that would be much more convenient.
Through the office of the PP.
Yes, your lordship.
Okay.
And my lord, for concerned police station of the private respondents, because they are resident of Sejasa,
No, we'll,
Pakistan district.
the normal steps is, in our case, your lordship, if they submit us with the copies, your lordship, we give it to the jurisdictional police station of that area, your lordship.
Okay.
They give us the report that the service has been done or not. So it's much more convenient. Yes.
Steps to the jurisdictional police station.
Police
through
station,
PP.
to
through
the office of the PP, yes.
To which the additional PP has no objection. Accordingly, the prayer is allowed. Stop. Does this service be taken? The petitioner is allowed to take.
Not dusty service, your lordship, only service, your lordship, because dusty
service.
would be only,
Okay, not dusty.
not dusty.
Okay, then leave the dusty, huh? Take steps upon the responding through the jurisdictional police station. So the office of the public regulator, the prayer is allowed. Steps be taken within a week from today, 1 week, huh?
Yes, my lord.
Within a week from today.
The documents bulky, so I need to xerox
Okay.
all the documents.
Within a week from today.
Within a week.
Start, huh?
Otherwise, lordship,
List this matter after. This is, if this is Sejosa, then it will take some time.
This will take time.
Time.
Yes.
So after 4 weeks, after 4 weeks.
Otherwise, my lord, this respondent, private respondent 3, 16, 2, and 5, they are well aware about the matter standing before this honor, this instant case. They are well aware. And they
Still bring it on record that they are well aware.
yes,
Okay.
much.
No one appears on call. List is matter after 3 weeks. Okay. Service upon the respondent number 2 is still awaited. List is matter after 2 weeks. Okay. This note dated 4/11/24 reflect that the service upon the respondent number 2 is still awaited. In view of the above, this matter after 3 weeks. Okay.
But this matter is pending in the same state since last 1 year.
Since last,
I have taken steps several times.
Your Lordship, on the last occasion, in fact, a step was taken. We have forwarded the notice upon the concerned police station. We haven't received the report, Your Lordship. If a week's time is granted to get the report of the service, Your Lordship.
service report noted received.
Yes.
My lord, may I pray to call for the request from the CPS Nahalagan as to why service could not be served to the respondent. Because I have taken it 3 times and it is in the same state since last 1 year. So we have to do something.
Your Lordship,
This was received, this time the step.
was taken through the PP's office, Your Lordship.
This was received on 28/10.
Yes, Your Lordship. We have sent the,
Around 10 days back.
we have,
And probably service report naturally. It
Yes.
will be awaited only. Now, where is the address?
it's shown as Nahalagan,
itself,
sir.
yes.
Yes. We'll get the report within a week, Your Lordship.
Within a week.
Because our PO, he's on election duty, Your Lordship. There is no one, it's to communicate with the police station, Your Lordship.
The office note dated 4/11/2024 reflect that the service upon the respondent is still awaited. Service of notice upon the respondent number 2 through the office of PP is still awaited. So, in this regard, the Larit ADPP, Ms. Cheney, shall obtain instruction upon
If the service has been completed upon number 2, Your Lordship.
My lord, that there is a provision for sending the notice through email also. I have order of High Court. That
So
step
this
will be
appears, the
taken
record
when it
reveals that PP has received those paper for steps only on 28.
Yes.
But now, by now it should come actually.
Yes, Your Lordship, as I have already explained, Your Lordship, our PO, who is the, who normally, when the notice are given, the
Okay,
PO, it's the
Miss-
duty of the.
okay. Genie and ADPP seek for, sought for 1 week time to obtain report from the OC PS concerned
Yes, Your
regarding the service of notice upon the respondent. Okay, the prayer resolution. This is matter after,
On 14th,
after a week. Huh?
on
14th.
14th, Your Lordship. Yes,
1 week, after a week. Okay.
deeply.
All right.
My lord, sorry for interruption. My item number 14 is possible. 14,
This is item.
17 call.
करेगा क्या 14 में?
2 weeks.
ये है ना, 14 है.
3 weeks. Okay,
Service awaited. Okay.
okay, ma'am. Much obliged.
15 or 16? This is 16. 16.
My lord, I am appearing for petitioner on behalf of T Tang, my lord.
Yes, you are for
I am for the petitioner, my lord.
petitioner.
Yes.
Who is for the respondent? Affidavit of objection not yet filed. Who was to file objection?
Responded, my lord.
Private respondents are also there.
Yes, my lord, only sole respondent, my lord. They are supposed to file
Okay, you're Mr.
M. Doji, my lord.
Learned counsel for the petitioner is present. The respondent has not yet filed. Affidavit in opposition. The respondent is not being represented. They are yet to file affidavit in opposition. In view of the above, please this matter after 2 weeks. In the meantime, the respondent shall file affidavit in opposition. Okay.
Obliged.
My lord,
Yes.
the investigation is still pending because of the non-receipt of the FSL. Matter has not been charge sheeted yet. And it's as on today, it's 66 days. But however, your lordship, if we go from the new BNSS, then it would be 90 days. If we go from CRPC, it would be 60 days.
So this is,
The application is
This
filed under
is filed
BNSS. BNSS.
yes,
Yes.
that's 90 days.
Yes, your lordship. Your lordship may kindly come to 187 of the BNSS, your lordship. Because your lordship, some changes are there in the provision in 187. Yes. Your lordship will.
It is 90 days.
Yes, your lordship,
90 days.
yes, in 187, the punishment is extend up to 10 years. Prescribe, your lordship, this punishment.
Up to 10 years.
Yes, extend up to 10 years. Now, may I read the provision of the BNSS, your lordship?
Okay.
The earlier, the
BNS.
word, yes, your lordship,
BNS.
okay. (187), the corresponding section of 167.
Yes, yes.
Bharatiya Nagrik Suraksha Sanhita.
What is
Your lordship, section 187
187?
of BNSS. This is the corresponding section of 167. CRPC repealed.
Yes.
Your lordship will find in subsection 3, clause 1.
90 days.
90 days where the investigation relates to an offense punishable with death is clear for death, imprisonment for life clear, or imprisonment for a term of 10 years or more. Earlier, your lordship, the word used by the legislature was not less than 10 years. But now it says term of 10 years. Now, if the punishment prescribed is extend up to 10 years, then the concerned court can punish him for 10 years as well, your lordship. And in support of my submission, your lordship, I will rely on judgment of the Honorable Supreme Court, wherein, your lordship, whether for the offense extend to 3 years will fall under the Schedule 1 or Part 2 or not, that has been explained by the Honorable Supreme Court. And the same things according to me, the same principle will apply here because it says term of 10 years or more. If the offense is extend up to 10 years, meaning thereby the concerned court has the power to imprison him or punish him for the 10 years as well. To that extent, your lordship, I will rely this judgment of the Honorable Supreme Court. Because, your lordship, the word has been changed by the legislature. Otherwise, it should have been kept ditto like not less than 10 years.
Not less than.
Yes, exactly. Your lordship, this is the judgment of the Honorable Supreme Court. Reported in 2020, 10 SCC 221. Para 10, 11 and 12, your lordship. To understand whether extend up to 10 years, your lordship, whether it will be termed as 10 or not, your lordship. The punishment prescribed can be prescribed by the trial by consent court. From para 10, your lordship.
Yeah.
Yes. Thus, for the offense under section 63 of the Copyright Act, the punishment provides is imprisonment for a term which shall not less than 6 months, but which may extend to 3 years, and with fine. Therefore, the maximum punishment which can be imposed would be 3 years. Therefore, the learned magistrate may sentence the accused for a period of 3 years also. In that view of the matter, considering part 2 of the first schedule of CRPC, if the offence is punishable with imprisonment for 3 years and onward, but not more than 7 years, the offence is cognizable offence. Only in a case where the offence is punishable for imprisonment for not less than 3 years or with fine only, the offence can be said to be non-cognizable. In view of the above clear position, the decision in Rakesh Kumar Paul relied upon by the learned counsel appearing on behalf of the respondent number 2 shall not be applicable to the fact of the case on hand. The language of the provision in part 2 of first schedule is very clear and there is no ambiguity whatsoever. Under the circumstances, the High Court has committed a grave error in holding that the offence under Section 63 of the Copyright Act is a non-cognizable offence. Thereby, the High Court has committed a grave error in quashing and setting aside the criminal proceeding and the FIR. Therefore, the impugned judgment and order passed by the High Court quashing and setting aside the so and so is set aside. In view of the above discussion and boarding reason stated above, it is observed and held that the offence under Section 63 of the Copyright Act is a cognizable and non-bailable offence. Here, Your Lordship, the Supreme Court has emphasized, even if it is extend up to 3 years, the concerned court can punish to 3 years, term of 3 years. And that has also been bring into the category of Schedule 1, Part 2 of the CRPC.
That's clear already. It's clear from the provision. for
Yes.
the-
Yes, Your Lordship. So now,
Yes,
this provision
term of
says,
10 years means can go up to 10 years.
10 years, exactly, Your
That
Lordship.
is-
Whether it doesn't say, use the word less than 10 years. It says term to 10 or more.
Here it-
So now, if it extend up to 10 years, the court is well within its jurisdiction to punish for a term of 10 years. Then it will fall under this category. Then it will be a 90 days. No, not 60 days.
That was cleared by the, my lord, Rakesh Pal case.
The Rakesh Kumar Paul, Your Lordship, will not apply in this case because Your Lordship may kindly come to the earlier provision of CRPC, 167. The Rakesh Kumar,
That is
In-
also after the, my lord, BNSS case.
no, Rakesh Kumar Paul was before the BNSS.
That is, your case is also.
I am on the extent for the punishment, the interpretation of the punishment, how it has to be interpreted, how the punishment has to be taken. Now, Your Lordship may come to provision of 167, the corresponding provision of 187.
One 167.
167, Your Lordship will find in subsection 2, clause A1. 90 days, where investigation relate to a punishment with death, imprisonment for life. This is same, ditto. Or imprisonment for a term not less than 10 years. Here is the variation here, substantial change. Yes, and basing on this, Your Lordship, Rakesh Kumar Paul judgment was pronounced by the Supreme Court, wherein it has been categorically laid down by the ratio of 2:1 bench judgment. It was held that even if the maximum punishment is life or death, then minimum will not need to be looked into. But if the minimum is 10 years, then even the maximum is not need to be looked into, but minimum has to be seen. If minimum is 10, then 90 days. But in the new code, it says for a term of 10 years or more. It doesn't say less than 10. Term of 10 meaning thereby the court, if court can punish to 10 years for a term of 10 years, that offense will also fall under this category of 1687 subclause 1, Your Lordship. So now they have approached this court, but
According to you, that it should be 90 days.
90 days, Your Lordship. According to me, Your Lordship, because they have invoked the provision of BNSS, Your Lordship, for filing of this anticipatory for regular bail application. Because, Your Lordship, otherwise, Your Lordship,
Going by the provision, it is 90 days, 90 days. it
yes, yes, Your Lordship. Because punishment prescribed in the NDPS of section 21B is 10 years, Your Lordship, extend up to 10 years. That is not disputed.
Okay, so 160 or 187.
If 187
Not
apply,
entitled for 187.
yes,
Okay, so it has to be hard on merit.
yes, Your Lordship.
You have any submission?
Yes, yes, I will submit the judgment related to the answer of my counsel.
What do you have to say about this?
My lord, I
This
will,
provision 187.
actually, previously I got bail, default bail in 60 days. Now this new point is come out, my lord.
90 days.
I will submit it today itself, my lord, if your lordship allow me,
What do you want to submit?
the against his judgment.
Okay, so you also want to cite some judgment?
Yes, yes,
Okay, when? Today?
today itself, my lord.
Okay,
Issue,
submit.
issue,
I have to bring it, my lord.
You have to bring it.
Your Lordship, my fair submission would be my learned brother has to satisfy this court whether the new BNSS will apply in this case or the CRPC. This would be the actually issue here, Your Lordship, to be decided.
This bail application has been filed under BNS.
Yes, yes, Your Lordship.
BNS, yes. So it will be under BNSS only.
Yes, Your Lordship. This is, if it is under BNSS, then it
that
should
case-
be,
That case, this will go on.
the entire provision of the BNSS has to be taken into consideration while dealing with the bail application or any, Your Lordship, application.
Now, you want to cite some,
Citation, my lord.
to present some citation.
Yes,
You want some time?
today itself, my lord, after 2 o'clock.
You do not know after 2 o'clock, yes. Today or tomorrow, we can take up tomorrow.
Yes, so let
Get
it fix
listed
tomorrow then.
Tomorrow, okay. Let's pray for by the Lana Council for the petition, list this matter. Tomorrow, we'll meet again tomorrow.
Deeply obliged, Your Lordship.
Item? 5 what? Okay,
My lordship,
yes.
my lordship, if my senior counsel agreed to the point that the impugned order may be passed and remand back to the trial before the district court alone, it would be appropriate if agreed. Lordship, what happened, Lordship? The village authority of Paya, Lordship,
So
Yes.
just a minute. You are for the petitioner?
petitioner.
You are for respondent?
Yes, madam.
Okay.
Respondents, madam.
So is there any other respondent also? You are respondent number 2,
I am appearing for all the respondents,
all respondents.
madam.
Okay,
My lordship,
so this is
civil division.
civil division.
Civil division.
Okay,
What happened, Lordship?
We
The
are
village
praying for a-
authority of
We
Paya
are praying
has.
for a disposal, madam.
Yes, Lordship.
Hmm?
We are
Disposal.
praying for a disposal, madam.
disposal today?
Yes,
Disposal.
Okay,
My lordship. The village authority of Paya, Lordship, has passed ex parte order, cover decision, Lordship. I am petitioner is from the Kabu village and the respondent is from Paya village, Lordship. Ex parte cover decision is, Lordship, at page 54, Lordship.
just a minute. So you want this matter to be taken up today for hearing?
Yes, Lordship.
Well, otherwise, the issue involved, my lord, of course, it might look voluminous, my lord. The issue involved is very less. My
We have to keep it for then hearing.
lord. This was,
List is for hearing.
this can be,
Tomorrow, day after tomorrow, for hearing. In the hearing list.
otherwise, this can be disposed.
Today,
It's the
Lordship.
admission
Dispose of
hearing
that.
also.
Yes.
You again say, okay.
Being agreeable of this order, Lordship,
Hmm.
I have prepared appeal, Lordship. Appeal under section 3 of section 15 of civil code.
15 of civil code. Act.
Before the district judge, allow, Lordship.
Now, who passed the initial order?
Village authority of Paya, Lordship.
Village authority
Paya village,
of which district?
allow, West Siang, Lordship.
Okay, they passed order.
Yes, Lordship.
Against that order,
Against that order, I have prepared appeal, Lordship.
appeal before?
Appeal before district judge, allow, Lordship.
Okay, then,
Then district judge allow by Lordship, order that has passed the order whereby the issue has, matter has to be decided de novo, Lordship. That order has been recalled. And the
No.
case is and the matter is fixed for the evidence lordship. Earlier, matter was decided to be heard, de novo trial lordship. Then de novo order has been recalled, lordship.
Yes,
That's
ma'am.
I am saying.
Let us see the order itself.
Lordship. Page 77, lordship. Annexure 11 series. This is order dated 23/8/2022. lordship. 77. lordship.
77.
Yes, lordship. Married,
So
lordship.
this is, this order was passed. This was in civil appeal.
Yes, lordship.
Appeal against the Kebang
order.
order. Okay.
Relevant parties, lordship.
Yes, ma'am.
Para 4, lordship.
What is this then? The next is order dated 26/9.
Yes, lordship. By
This is also
26/9,
in civil
lordship,
appeal.
the counsel for respondent was to file, was instructed to file a press petition, lordship, without amending any nature of the
No, after this.
appeal.
This, the para, on page 77,
Yes, lordship.
annexure 11 series.
Yes, lordship.
The first one, page 77 is the impugn order.
No, no.
Hmm?
Impugn order is at lordship, page 80, lordship.
Then what is this?
By this order 23/8, lordship, the learned trial court has decided the matter to be this in de novo trial. lordship. Kindly see, lordship, para 4, married, lordship.
Let us read the entire, from the second para.
Lordship. Under section 15(3) of the APCC Act, on presentation of such appeal, this court can either hear the appeal petition or try the case de
You
novo.
are reading which one?
Page 77, lordship.
Page 77, para 2.
Para 3, lordship.
Oh, para 3, okay.
Under section 15(3) of the APCC Act 2021, on presentation of such appeal petition, this court can either hear the appeal petition, lordship, or try the case de novo, lordship. Relevant one is the lordship. Next para, lordship. The learned counsel for the parties submit that this matter is pending since 1986. Also, there are large number of petitions and documents filed by the parties. Therefore, it would be appropriate to proceed the matter de novo, lordship, by giving parties to file a fresh petition and fresh reply on the petition. And by this order, lordship, respondent has filed, lordship, appeal, lordship. Actually, they are the first
The
complainant.
provision of law, wherein
Next order, lordship.
Okay, the court has decided
Yes, lordship.
to try the case de novo.
De novo, lordship. And directed the respondent to file a fresh petition, lordship. Whereas actually I am the appellant, lordship.
So the respondent is directed to file fresh petition.
Yes, lordship.
Okay, thereafter what happened after?
Thereafter,
this order?
lordship, the impugn order, that is at page 80,
So
lordship.
the next is, it was fixed for 26.
Yes, sir,
And the
26
26
9,
other order, let us see the 26 order.
26 9, Lordship. Married, Lordship.
Yes, please.
Third para. This matter is under de novo trial before the DC court under the second provision of subsection of the section 15 of the Arunachal Pradesh Civil Code 2021 for trial of the de novo by this court if deemed fit in the given case, Lordship. Mr. So and so shall furnish the copy of press petition, Lordship, to Mr. So and so forthwith on filing of the same, Lordship. Next date is fixed on 7/11/2022. Lordship. That order I have not annexed, Lordship. Impugn order
That
is
order, you have not annexed
Yes,
that order. Okay, what is this order? Next is
next, Lordship. This is the impugn order, Lordship. 13/1,
13-1 is.
2023.
Okay.
Now I am
Let us-
agreed by the Lordship, page 81. Kindly see, Lordship.
Page 80.
81.
Just let us see the fact. Para 2.
Married.
Hmm.
This court by order dated 23/8/2022, considering the fact that this case is connected to the dispute started in 1986 and there are the petition and counter petition between the parties. With the consent of the Lord Council of the parties, had allowed to file a fresh pleading lawsuit before this court with the condition that they shall not add any fresh fact or ground in the new pleading. Accordingly, Mr. So-and-so, that is respondent lawsuit here and now, was allowed to file his petition as a petitioner lawsuit. Because it was his client who first filed the complaint petition before the Kava and thereafter Mr. So-and-so was asked to file a reply to that petition. Accordingly, Mr. So-and-so has filed new petition lawsuit, a copy of which was furnished to Mr. So-and-so. However, there is an objection from Mr. Nosi that there are new pleadings and new facts have been added in the fresh petition, which was denied by the counsel of the respondents. Next paragraph. After hearing the counsel for the parties sometime, this court is the opinion that giving liberty to the parties to file new pleadings may complicate the matter. Therefore, with the consent of the learned counsel for the parties, it has been decided that the order dated lawsuit 23/8/2022, whereby matter was to be decided in de novo lawsuit, passed by this court, giving liberty to the parties to file fresh petition, should be called back. Accordingly, it is ordered that with the consent of the learned counsel for the parties and to avoid any complication in the case, the order dated 23/8/2022 passed by this court in the case is hereby recalled and same stand cancelled. Same
Very
stand
good.
cancelled.
Initial-
And the next lawsuit, next para lawsuit. In view of the above, the press petition filed by Mr. So-and-so is, in the case is treated withdrawn lawsuit and Mr. may collect back the same from this office. That I am agree by this lawsuit. The case shall proceed with the appeal petition filed by so-and-so and filed by the stage of further proceeding shall start from evidence lawsuit. Without the framing of issue lawsuit, direct evidence lawsuit.
So, de novo trial without filing petition, now it will start.
Yes.
On the basis of the appeal filed by
Appeal
the,
filed by me also.
and the reply filed by the.
De novo order has been recalled lordship. Then by the impugn order lordship, the matter is fixed for the evidence lordship.
Okay, then. You are agreed by this?
Yes,
Agree by which one?
13/1 lordship. Yes. 13/1/2023.
No, 13-1, this, to proceed with the appeal petition filed by Sri so-and-so and reply filed by Sri so-and-so. You are agreed by this?
Agreed by lordship for the evidence part lordship. No issues has been filed lordship. The learned trial
No,
court has
in
then,
the stage of further
Yes.
proceeding. If that is to be treated as petition, then it has to start with the evidence only. If that is to be treated on agreement, entered into by the parties on this date, as it is to be proceed with the appeal petition filed by so-and-so and reply filed by so-and-so. Then what next? Next is issue.
Yes, Lordship.
What you want?
Lordship, issue may be framed, Lordship. It may be decided as per a law, Lordship.
So the one step, according to you, the
Yes, yes.
issues has been
Issues not framed, Lordship, and the de novo order has been.
skipped.
Yes, skip and de novo order
So
has been
you
recalled.
want the issue to be framed first.
Yes, Lordship. And this recall order may be, Lordship, set aside, Lordship.
No, only
15.3 Lordship provide for the de novo or Lordship.
if it is a civil trial
Yes, Lordship.
and probably issue need to be framed
Yes, Lordship.
So, my
first.
lord,
What is the issue is to be decided first?
my lord, my lord, here, I've been trying to understand what exactly my brother is trying to say. I'm not able to understand. He's agreed by the evidence part. Now he also says that it should be, this recall order should be de novo
No,
trial.
That-
I
that-
don't
that
exactly
was-
want
That order was passed on
consent.
being agreed by the agreed upon by the parties.
Yes.
It was passed on consent.
Yes.
This is a consensus order.
Consent
This
order.
cannot be set aside. Only of of course, the procedural part, that the issue is, the stage of issue has been
No, my lord.
appeared, skipped.
My lord, dear, my lord, no, my lord will see, my lord. This is the Civil Courts Act, my lord.
Is the only order that you are agreed by?
Yes,
Yes, the only order he's agreed by is a 13 years, which
Okay.
is a consent order basically. Now, my lord will see, my lord. This is an appeal, my lord. These orders were passed in an appeal, my lord.
Yes,
Appeal from the orders of the village authorities, my
and that this appeal
my lord.
was.
In
into
the
the
appeal,
court's,
whether, my
own
lord,
cons-
whether in an appeal, whether issues are necessary to be framed, my lord.
No, no. In the appeal, issues cannot be. But
Yes,
then-
my lord.
But then probably he is agreeing because the next date is fixed for placing evidence only.
Yes, my lord.
And then before placing evidence, it has to be, of course, the issue is to be decided.
My lord will see, my lord. This issues, my lord, of course, they are basically when
No,
the
even if the evidence submitted also, issue can be framed. But later on, also issue, without issue, the court will not be able to decide.
yes, Lordship.
Issue, in any case, the issue, the court has to frame issue.
my lord, that can be done, my lord. Let issues be framed otherwise also, my lord. Because, but when the
But in any case, this cannot go because this is a consensus order. But then the procedure has to be followed, of course.
no, that can be done. Basically, what the earlier learned district judge said was that I should be the appellant, my lord. I should be the plaintiff, my lord, by filing
Who is the complainant in the?
in the
before the
original
Kiba?
before the deputy before the Kaba, my lord. I am the complainant, my lord.
Then you should be the petitioner.
No, my lord. The order was passed in my favor, my lord.
Okay, in your favor.
Yes, my
Then
lord.
he.
And then he went to appeal, man.
Okay,
Now at the time,
he went to deputy commissioner,
not the district judge, my lord.
district judge.
Yes, ma'am. In
He-
terms of this Civil Courts Act, my lord. In terms of the Civil Courts Act, my lord,
In the form of appeal.
appeal, yes.
Okay, appeal, okay, this is the order passed then thereafter.
Yes, this is an order passed in an appeal, ma'am.
Okay, now accordingly, since he is the appellant, then he should be the petitioner.
Yes, my lord.
It was decided.
No.
Okay,
Now
So-
it will proceed as an appeal, my lord.
no, now the novo trial.
De novo trial, my lord, that has been called, man. Because otherwise, what the district judge said, my lord, in the de novo trial, I should be the plaintiff. I cannot be forced to be the plaintiff, my lord. There's an order in my favor. Person who is there, my lord, who is agreed, my lord, he is the appellant,
He
my
is
lord.
the, he
Yes.
is the appellant and he should.
He should be the petitioner, my lord. That should be the case, my lord. But I was directed to be the plaintiff. But of course, that order has been said, recalled, my lord, by the consent.
After recalling the appeal filed by him has been treated as the plaintiff. Now, petition.
Now, yes,
Yes,
my lord, now.
Okay, and then the reply filed by you is been treated as a written statement.
My lord, that.
Because
Yes,
otherwise there
ma'am.
was a complaint that new evidences are also new facts
Mm.
and circumstances are also coming. So that is why it was decided.
Mm.
So now, on the basis of this appeal and the reply, which will be treated as the petition
Mm.
and as well as the written statement,
Mm.
on the basis of the pleadings of the parties, probably the parties are to ask to submit the draft issues and issue the frame without jumping in directly to the evidence.
Evidence.
Evidence, because evidence will be recorded on the basis of the, evidence will be adduced on the basis of the issues only.
Issues only.
On the issues framed by the court only, the evidence will be adduced, and otherwise it will be problem. So this probably, it appears that one procedure, the issue portion has been, of course, skipped.
Man.
So he wanted the issue be framed first,
That can
That can be
man.
done.
That can be done, man.
or what?
That
direction
can be done.
given.
That can be done, man.
That the before proceeding, the probably the evidence has not yet
No.
started.
Not start.
Okay, noted, okay. Because then we can pass order
Yes.
saying that this order probably,
But
while
otherwise,
passing this order.
yes, otherwise, my lord, not
Hmm.
my lord. This 15(3), it says that
Yes.
the district judge or the court of additional district judge may dispose of the same or proceed with the case de novo.
Yes.
Now, what happens, my lord? There are two methods, man.
Hmm.
One is the disposal, and another is a de novo case, man. Now, in our, of course, our High Court has also said, man, which procedure is to be followed, my lord. There are two options before the district judge. Now, our court has also said, when the judge decides, district judge decides to proceed with the case de novo, then only the CPC will be applied, man. But otherwise, when it is treated as an appeal, my lord, and decided, man, then since my lord knows that appeal is a continuation, my lord, of
Yes,
the
appeal is
CVS.
continuation of the.
So, and in the village, before the village authorities, since the CPC is not applicable, when it's treated as an appeal in continuation, the CPC cannot be strictly applied. That our court has also said.
So, no, this would be this, it appears, although the novel trial has been recalled,
Mm.
but then it appears that by this order, treating this appeal as a petition, appeal petition, proceed with the appeal petition filed by the so-and-so and replied by so-and-so. The stage the further proceedings shall start from the evidence. So these probably by this order, one stage, because it appears that in any case, by treating this appeal petition, appeal as a petition and reply filed by the respondent as a written statement, it's almost a de novo trial only.
Yes.
So,
My lordship, section
Then,
18 of
my
the
lord-
civil code,
my
Act,
lord, that-
lordship.
Then I have no issues, my lord. Just not to complicate the matter, but let issues be framed, my lord. I have no
Okay.
issues with.
So that consensus with the consensus, that order will be passed.
Yes.
Okay.
My lordship, section 18 of the civil code, Act, lordship, is strictly talks about the lordship, implication of the code, lordship. Code, that is this code of civil procedure, lordship, section 18 of the Act, lordship. Civil code,
Section?
Act, 18, lordship. Kindly say, lordship, section 18, lordship.
What it says?
Although the CPC is not applicable in the village level, lordship, village authority, but lordship, as per section 18, lordship, may I read, lordship?
Yes.
The procedure prescribed in the code, lordship, code means civil CPC, lordship, save in so far otherwise provided by this act, the procedure followed in all the civil court except the customary court. CPC has not been followed, lordship, by this order, lordship, impugnal, lordship.
But my lord, CPC has to, but we are not dealing with, but man, just to point out certain thing, man. This is clear, my lord. This is a misconception by my brother, man. This has been decided by, if your lordship would come to paragraph 22 and 23, man. At page 13.
Yes.
this, since the section 15 provides for de novo as well as the disposal matter, how it's to be dealt with matter, that has been reflected. Para 22 matter. Thus, in order to resolve the problem which has arisen, this court is of the opinion that the second proviso to section 15 of the Act of 2021 may throw some light in as much as the second proviso conceives of a situation when an appeal is against a judgment of the customary court, which is a civil court within the meaning of section 2B of the Act of 2021, is preferred to the court of the district judge or the additional district judge. Power has been given to the said courts to dispose of the same or proceed with the case de novo. The expression dispose of the same is very relevant in as much as the court of the district judge or the additional district judge have been conferred with the powers of the appellate court. The expression or proceed with the case de novo implies that court of the district judge or the additional district judge shall have the power in the alternative to try the suit de novo, or in other words, decides afresh like a trial court. It is also pertinent to mention that in view of the first proviso to section 15 of the so and so, this is not para 23. Another question arises as to what procedure to be followed in as much as reading of section 18 of the Act of 2021 stipulates that the procedure prescribed in the Code of Civil Procedure 1908 shall save as otherwise provided in the Act of 2021 as the procedure followed in all civil courts except the customary courts. And section 52 of the regulation was so and so. Taking into consideration that in the customary courts, the Code of Civil Procedure 9 is not the procedure to be followed. It is observed that when the district judge or the additional district judge is exercising appellate jurisdiction against the judgment of the customary courts, the said courts of the district judge or the additional district judge shall be guided by the spirit of the CPC. This is so because the appeal is a continuation of the civil proceedings adjudicated by the customary court. This court has sense to add that when the court of the district judge or the additional district judge exercises the jurisdiction to proceed with the case de novo, the said court shall be bound to follow the procedure mandated in the CPC. This is how, my lord, the section 18 has to be read, my lord. Just because it said it shall be present. When an appeal against the customary court, my lord, the spirits will only follow, my lord. This is just for, my lord, for us, my lord, academic purpose only, we're discussing, my lord.
When the court of the district judge or additional district judge exercise the jurisdiction to proceed with the case de novo,
Yes, ma'am.
the said court shall be bound to follow the procedure mandated in the. Okay. But here is the case where the de novo trial has been recorded.
No, my lord,
That
since
is
my
the procedure.
brother mentioned that
Silent
section
procedure.
section 18, this is to be followed. That's why just this is basically academic only this part. When the CPC will apply, when the spirit of the CPC will apply before the district judgment. There are two possible ways. But here we are agreeing, my lord, let issues be framed and then it will be proceeded, my lord, in that manner.
Heard, Mr.
Elban, Lordship.
And counsel for the petition. I've also heard, Mr.
This okay, ma'am.
It's okay. Land counsel appearing on behalf of. You are appearing on behalf of all the respondent.
All the three respondents, ma'am.
Okay, respondents. All the respondents, huh? Start, huh? By filing this civil revision. Application under Article 227 of the Constitution of India. The petitioner You are agreed by just 30, 10, 21 only.
Yes, Lord. Kabang order, Lordship, that has been,
I
that
say
I
order.
have highlighted.
Order dated 30, 10, 2021. Passed by the learned District Judge Alo. Whereby the court has recalled the order dated 23/8/2022 by which the parties were directed to file fresh petition and also fixed for evidence from the appellant's side. By fixing next date on 22/2/2023. In violation of Order 41 of Code of Civil Procedure and 1908 and Section 15 of Arunachal Pradesh Civil Code Act. Start. Where have you stated the fact of the case?
Para 4,
Please.
Lordship.
Para?
Page 6, para 4, Lordship.
Where have you stated now? Where is the Yabans order?
Kabang, Lordship, I have stated in para 10, Lordship, page 12, para 10, page 12 of my petition. 12 and 13. Lordship.
The case of the para, no? The case of the petitioner. The brief fact of the case of the petitioner is that he being agreed by the ex parte Keba order.
Yes, Lord.
Well, page 10. Sorry, para 10.
Para 10, Lordship. Page 12.
By the agreed by the ex parte Keba decision dated 30/10/2021. Passed by which Keba?
Village Authority of Paya, Lordship.
By the village authority of
Paya Village.
Paya
Village.
village. The petitioner preferred an appeal before the district judge.
Yes, Lordship.
The court of, before the court of the district judge, Alo.
On Lordship, 29/11/2021. Lordship. Appeal was filed on 29/11/2021.
29/11. It was filed on 29.
Yes, yes, Lordship.
Which one, which was registered as? The appeal, where is the order passing the appeal? appeal number, where do we find? Civil appeal number 11/2021.
Page 74 also.
Hmm?
Page 74 also.
Civil appeal number 11/2021. Against the Keba order dated 30/10/2021. Stop. On 2/12/2021, by this order, decided to proceed with the de novo trial.
No, Lordship. It was only fixed for the filing of written statement, Lordship.
Okay. So where is that?
De
where is
novo
the
order
de
is
novo
at
trial order?
Lordship, page 77. By the
Okay.
order dated
By an order
23/8.
dated 23/8/2022. Where is the operative post? The Lanet district judge. Decided to proceed the matter for de novo trial by giving the parties to file fresh petition and fresh reply on the petition. Just a minute. By which order you were allowed to file reply? The respondent was allowed to file reply. Earlier order.
Yes, by this order, Lordship, respondent was filed to file appeal, Lordship. By this order, Lordship.
Okay, by this order only.
Yes, Lordship. Respondent was allowed to file appeal, Lordship. Petition passed. Then I have to
But that
file
was
reply.
withdrawn again.
Yes, yes. That was- It was withdrawn by the inferior Lordship.
Accordingly, the petitioner, you file petition thereafter.
No. Respondent has filed, Lordship.
Petition.
Yes, yes.
As a plaintiff,
Yes, as a plaintiff.
Okay. Accordingly, the respondent herein has filed a petition, the fresh petition, and the petitioner, you have filed written statement.
No, Lordship.
Hmm?
No.
No,
No.
you did not file anything. Because
No, Lordship.
you filed reply.
No, as per this order, I have not filed.
Whether the present respondent has filed petition thereafter.
That has been withdrawn by the inferior Lordship.
No.
Yes.
But filed.
Yes, filed, Lordship.
You also filed your written statement.
Kindly
Did
see,
you file?
Lordship, page 81, Lordship. Page 81, para 3, Lordship. Third para. May I read, Lordship? In view of the above, the press petition filed by Mr. So and so is treated and withdrawn, Mr. Tasso may call.
However,
Yes, sir.
okay, which one? Okay, however, by an order dated 13, by the impugn order dated 13/1/2023, comma, not, comma, the first petition filed by the respondent herein has been tweeted to have withdrawn. Stop. However, by the same order, said order dated 13/1/2023, the learned District Court, Alva, has where is the decision to proceed with the de novo trial has been recalled? The Lanet Court, by the same order decision, so Lanet District Court has directed has ordered that the case shall proceed with the appeal petition filed by who Jumkar Roy is the petition appellant.
Appellant, Lordship. Here is petitioner, Lordship.
Here petition, okay, filed by the petitioner hearing and reply filed by the respondent hearing. So, further, the learned court has ordered that the stage of further proceeding shall start from evidence. And the next date of the case was fixed for placing of evidence from the appellant's side. Stop, para. It is the said order directing for proceed with the case, directing for further proceeding of the case from the evidence stage, comma, that the petitioner is aggrieved by and file this civil revision petition. Stop. Para. Civil revision petition. At this stage, at this stage, the learned counsel for the petitioner made it clear that he is not aggrieved by the entire impugn order dated 01/2023. The only order by which the petitioner is agree is that the Lanet Court, comma, without an order for framing of issues based on which the case would proceed, has straightaway order for further proceeding, order that the further proceeding of the case shall start from the evidence by fixing next date for placing of evidence from the appellant's side. Stop. Para. Mr. Farah, is okay. Lanark Council appearing on behalf of the respondent, all the respondents. Oh, then, before that, it is submitted that in the civil case, the stage of framing of issues is an important, and without deciding the issue, the evidence, it would be difficult to proceed with recording of the, proceed with adducing evidence in the case. Hence, the only prayer of the petitioner is that before proceeding with the evidence, an issue, the parties may be allowed to submit draft issues. And after framing of issues only, the case may proceed with the recording of evidence of the parties. Stop. Para. Mr. Disoki, appearing on behalf of all the respondents, has also had no objection with the prayer so made by the Lanark Council for the petitioner. Stop. He has also considered the submission made by the Lanark Council for the petitioner that before proceeding with the case for recording of evidence, the issue need to be decided. The issue need to be decided. And accordingly, we need to be decided. Stop. Para. Not the issue need to be, the court, the Lanark court required to decide the issue first. Okay. Okay, then thereafter, in view of the above, and on on the agreement of the parties, this civil revision, I propose to dispose of this civil revision with direction that before further proceeding into the case, from the stage of evidence, the learned court shall decide, shall allow the party to submit their respective draft issues, and thereafter an issue be framed, and only after framing of the issues, the further proceeding shall start from the evidence of the appellants. Okay, with the above observation, this criminal civil revision petition stands allowed to the is allowed at disposal. Okay.
All right.
Yes.
Yes, Your Honor, I'm seeking adjournment for today. The leading counsel, Mr. Tabatupu, is having ill health, so. he
Yes.
could not be- Leading counsel, Mr. Tabatupu, is having ill health today, so I'm
Okay,
seeking
you are for the
adjournment for today.
petitioner.
Yes,
This is 17.
yes,
Okay.
and
Mr.
item
You're
number-
Mr.
Tempahi. Item number 18.
Okay, Tapu is out of station.
Yeah, having ill health.
Hmm?
Having ill health.
Okay. Mr.
Tempahi.
Banner Council submit that the leading counsel, Mr. Tabatapu, is indisposed, and hence pray for adjournment of the matter for how many days?
2 weeks.
2 weeks.
I'm E Pang on behalf of respondent number 2, private respondent number 2.
Okay. Otherwise, this matter is ready for whether all the respondents are
Yeah,
present.
there is only
Early. Okay. Okay.
item number 18 also.
18 also.
Yes.
Yes.
Item number 18 is joint.
Hence pray for
joint-
adjournment of the matter for 3 weeks. The prayer not objected. Accordingly, the prayer is allowed. List is matter after. You said 2 weeks or 3 weeks?
2.
2 weeks. Okay. 18 also same. Okay.
All right.
I'm appearing for the petitioner, Jindo Doro.
Yes.
I am appearing for the petitioner, Jindo Doro.
You are for the petition.
Appellant.
Hmm?
I'm appearing for appellant, Jindo Doro.
Okay.
Yes, madam. We have taken steps, madam, for the respondent.
Taking steps.
Yes.
Sorry. What is this?
This is criminal appeal.
Accused is on bail,
Yes, madam.
convicted for
Convicted by zero session court.
zero, for, period of,
Zero session court.
okay. For how many years?
For 3 years.
3 years. Under section
Under section
10. You have taken steps upon the respondent number. Have you impeded the respondent, the victim?
Actually,
It appears we have
the
not
case is,
impeded.
the case is passed the judgment on the basis of section number, section 354B or 506 IPC.
This POCSO Act, you have to
Yes.
impede the victim also. You have not impeded the victim as a respondent party.
Your Lordship, in fact, though the matter was registered under that, it seems if Your Lordship will come to page number 130, Your Lordship, he has been convicted under 354B.
Page 1,
130, Your Lordship.
yes,
354B and 506, Your Lordship.
not under POCSO.
Not under POCSO.
Then no need to make,
No, not necessary, Your Lordship.
whether a record was called for, necessary to call for record, I think it's necessary. It is necessary, record.
Record would be necessary, Your Lordship.
whether
Record
the
may be
record
called
was
for.
called for.
Yes, ma'am.
When?
The last occasion or 12/9/2024, the case is.
12/9.
Yes.
What is the order?
But
This is the first time.
this is second time.
Second time.
Yes.
What is the
In
order?
last occasion, the file was missing by this court, my lord, as the matter was stayed, ma'am.
No second order.
Yes, ma'am.
Where is the second order? Do you have the copy of the second order?
First, this is the first.
Today is the second time the case is listed, madam.
Okay.
First on 12/9/2024.
It was not on 12/9, it was 11/9.
Your Lordship may in that case call for the records, Your Lordship.
Okay. You are Mr.
Pramod Kumar Ghosh.
Mr. P.K. both of them. And counsel for the applicant. I've also heard Mr. Lee, Planet Edison P.K. In the instant case, the record would be necessary for proper identification of the case. Accordingly, call for the trial court record. You have taken upon him, taken steps upon him.
Upon the registry, zero session court.
No,
For whom?
that's the state.
It was
that
received
we
by-
have received, Your Lordship.
Received only, I think. List the matter after receipt of the record.
Yes, yes.
Okay.
Deeply.
On receipt of the record, okay.
Deeply.
Yes. Yes.
Lordship, on the last date, the learned council has surpassed affidavit on opposition, and in that regards, we would like to seek some more time to file the rejoinder.
Lordship, since the matter, the trial court, since this court has stayed the matter before the trial court, so if this can be taken at the earliest.
What is this?
Lordship, in this case, this
IA filed by whom?
IA filed by,
IA for what?
Sir, for stay.
Stay,
Yes, sir.
stay of the,
Stay order of
stay of the proceeding before the lower courts, Lordship. And accordingly, this honorable court has stayed the matter.
okay. Order already passed.
Yes. And we have filed the, I filed the affidavit in opposition. So today it speaks for orders.
By this order, the proceeding was stayed.
Yes. Therefore, since the proceeding has been stayed, this matter may be taken up the earliest. If they want to file rejoinder, then
Have you
sure
received
that may
the
be given.
affidavit in opposition filed by the?
Yes, sir.
Okay. You are Mr.
T. Chishi.
Mr. T.
Chishi. CHISHI.
And counsel for the petitioner who submits that he has received a copy of the affidavit in opposition filed by the sole respondent. Respondent is only one respondent.
Yes.
Not sole respondent. You want to file rejoinder? No.
Yes, we want to file a rejoinder on the next.
And prays for some time to file affidavit in reply to the affidavit in opposition, so filed by the learned counsel, filed by the respondent. So. We are allowed to list this matter after 2 weeks.
Yeah.
After 2 weeks. Mr. You are Mr.
H. Apne.
Learned counsel for the appear on behalf of the respondent, the sole respondent. Okay. Okay.
May I, Lordship?
Yes.
Lordship, there was a direction by this honorable court to settle the matter outside the court. Since this is a money shoot, the matter could not be settled, Lordship. This is basically, Lordship, this is regarding, we have come before this honorable court challenging the pre-suit passed by the Civil Judge Senior Division, UPN. Lordship, may I, Lordship?
Yes, please.
Lordship, basically this is RFA is against the impugned judgment and order that passed by the learned Civil Judge Senior Division. The judgment was passed on admission. Since, Lordship, in our WS, we have admitted that we have taken a sum of such and such. And Lordship, the Honorable Civil Judge has given the pre-suit amount. So basically, Lordship, after filing of we have paid the principal amount. That is not a disputed fact, Lordship. Only, Lordship, the Honorable Court has to decide whether the interest given by the learned Civil Judge Senior Division is as per the law or not, Lordship. So that,
What is the interest given by the civil judge?
Lordship, he has given a pre-suit of 3.5 per month.
Per
So,
month?
Yes, Lordship. Even in CPC, Lordship, it says 6% per annum in a month, and that also, Lordship, it usually give when there's a the
The money
transaction
was taken on loan basis,
on loan basis, Lordship.
at the interest rate of
There was a promissory note, Lordship.
promissory note.
Promissory
So
note.
to pay the interest also,
Yes, Lord.
how much?
Lordship, as of now, we have paid only the,
No, no, as per the promissory note.
it says 3.5 per month.
Okay, accordingly, the civil judge has passed for 3.5
Per month, as per the
Per month.
promissory note.
per month. So you are agreed by the interest part?
Yes, Lordship. And Lordship, here since absence and Lordship,
So in the settlement, who paid?
in settlement, Lordship, before filing of money suit, since the amount was 1 lakhs, 1 crore 70 lakhs. Before filing of that, I had already paid him 1 crore.
The
5 lakhs.
principal amount was
Principal amount would be, Lordship, 61 lakhs, like
61 lakh, and you have paid till now, you have paid?
I paid all the principal amount, Lord.
Okay, and interest?
Interest, Lordship, I have not paid, since the interest amount is more than the
Some
principal.
amount you have to pay interest.
Lordship, that's what I'm saying, Lordship. I'll pay as per the CPC. I'm not disputing that also. As per the law, Lord, CPC says that Section 34 says that it has to be 6% at maximum when there's a commercial transaction between the party. But since, Lordship, this is a private loan, and that also, Lordship, the how
What,
the
what was the negotiation? What was your negotiation with the respondent?
Lordship,
For
we
payment with regards to the interest?
Lordship, that's what we have been saying. We'll be pay as per the
You are
minute.
ready to pay 6% per annum?
Yes, Lordship, from the date of judgment, Lordship, but not the pre-suit, Lordship.
Date of judgment?
Yeah.
No, you have not yet paid any amount as interest.
As an interest, as of now, Lordship, I have not
Then
paid.
in that case, we have to pay from the very beginning.
From date of
when-
filing, Lordship.
Date of filing.
That also, Lordship, we
No,
agreed
since
from,
you have not paid any amount.
Lordship, before
What is
filing.
the agreeable amount you supposing if proposed? Because in any case, if the case is settled by the High Court, probably the 3% monthly will be difficult to agree with the monthly interest. What is your claim, basic claim, the minimum claim?
My lord, my client,
Yes.
once the pre-suit interest, according to the judgment and decree impugned in this appeal,
Yes,
that is 3.5%.
yes, that is impugned. So what I am saying is probably 3.5 may not survive. We do not know exactly, but it may not survive monthly, but then it may direct yearly certain percent. So of course that we have to examine what is the bank interest, etc., or as per the CPC also.
My lord,
But then what is your agreed amount, say, for example, if you're asked?
so my lord, as per the
It has to be negotiated.
as per the direction of this honorable court, efforts were made to settle the matter
Yeah.
outside the court,
Okay.
but no settlement could be reached.
Okay.
Therefore, my client is claiming the pre-suit interest as per the impugned judgment and decree.
Okay.
Therefore, lordship may kindly hear us on a merit and pass any order accordingly. We are ready to comply with any order passed by this honorable court.
Okay. So he has, your client has not instructed to make any proposal.
Any proposal.
Okay.
Therefore, my lord may kindly hear us on merit after post lunch.
Okay. So, up to-
Yes.
May I, Lordship?
Yes.
Lordship, this basically now since the principal amount also has been paid, basically our it's against the pre-suit interest which has been imposed upon us, that is 3.5% per month.
So your only grievance is that the interest is
3.5% per month.
is that 3.5% is an excess.
Yes, Lordship, that is that is which is against the public policy. Before the Lordship coming to that, Lordship, I'll just highlight the brief fact in a nutshell, Lordship.
Just a minute. On the
Page 18, Lordship, is the
no, just operative, just this is only to the plaintiff with interest rate of interest of 3.5% per month on the principal sum from January 19 till date of filing of the suit,
and interest
with interest at the rate of
6% from the
6%
date.
per annum on the sum adjudged from the date of the suit to the date of decree with future interest at the. So this 6% they have given.
No,
the
Lordship,
court.
it says 3.5% on the principal sum that was loaned from January 2009 till the filing of the suit.
No, yes, till filing of the suit.
Yes, sir.
And you are liable till filing of the suit. Only after filing of the suit, this will apply.
That's what, Lordship, if you count 3.5, Lordship, the degree amount given by the Honorable Civil Judge is 61 lakhs. If you calculate, Lord, it comes to 91 lakhs, the principal amount, the amount which I have to pay to the respondent. Counting.
Now, what is wrong in it? Because
Lordship,
only after filing, prior to filing, the Land Court has not passed order.
No, my lord, there are three parts, my lord.
The past order only because not past order from the court side, and it will apply the interest fixed by the parties, isn't it? Till filing.
Pre-suit interest.
3.5%. And only the 6% applies only after filing.
Yes.
So you meant to say that according to you, this 3.5 prior to filing should also be 6%.
No, sir, that is exorbitant, and Lordship, that cannot be given by the learned civil judge senior division, Lordship. Lordship,
So from say 2019 to when it was filed?
it was filed
25th August 2022.
2022.
Yes.
So 19, 20, 21, 22, 3 years. Monthly 3.5.
3.5.
That is of course exorbitant, it appeared. But then since you have agreed, as per the agreement.
As per the promissory note, Lordship, it says 3.5. Even, Lordship, if it's agreeable, Indian Contract Act said, Lordship, which is against the public policy, the court cannot give assent to it, Lordship. Say suppose, Lordship, for an example, today I make my friend that I'm going to pay you 7% per month. The Honorable Court cannot impose that. Lordship, it says that that has to be as per public policy. And for public policy, Lordship, if you go to the CPC, section 34, it says 6% at most. That also when there is a commercial transaction between a party. And Lordship, here in our case, it was never a commercial transaction. And Lordship, you have to see how the loan was taken from the respondent. That's why, Lordship, I said I'll just highlight the brief fact, how the loan amount was taken from the private from the respondent, Lordship. That also has to be seen, Lordship.
Okay, so what do you want to say?
Just here, Lordship, the appellant was representing a village, a group of villages, Ser Dukpen. There's a consisting of 14 villages. So I was the chairman of that village council.
Okay.
Lordship,
chairman of village?
That is consisting of 14 villages. It's in Rupa, Sergaon, Lordship. There's in like the border road organization, the defense had acquired our land in the year 1960, after year 1962, Lordship, when there was Chinese aggression.
Okay.
And Lordship, that land was duly acquired without paying us a compensation. Okay. And Lordship, since the compensation was ought to pay to us, since the government of India didn't pay us, so we had engaged the respondent as our counsel with some term and agreement saying that if some the amount is given, there was some agreement between them. I'm not going to that. Lordship, after a few representation given by the private respondent, who was our legal advisor, an amount of something about 70 crore was, some amount was given to our village council. And from that amount, Lordship, I had taken saying that since I'm doing some business, I had loan from him 1 crore 70 lakhs. That amount was never taken from him. That amount credit which the government of India has given to us from the land compensation. So I had taken his share, Lordship. So that how the loan agreement was taken from him. So that's why, Lordship, I'm saying since it's the loan agreement was not a commercial transaction, nor it was the money taken from, no doubt, Lordship, it was his share of amount which I was supposed to pay that for as a legal advisor, Lord. So, Lordship, since I had taken the loan amount of 1 crore 70 lakhs, before filing of this money suit, I had already paid him 1 crore 5 lakhs. And the remaining amount was 61 lakhs. That's why, Lordship, in our written WS also, we have said we have partly admit and we have partly denied. On that basis, Lordship, we have said we have taken a loan of 1 crore 70 lakhs, but since they had claimed around 3 lakhs 26, some huge they have exorbitant amount. On our WS, Lordship, we have clearly mentioned that we have taken the loan amount of 1 crore 70 lakhs, and the rest 1 crore 5 lakhs was returned to them before filing of the money suit. And Lordship, after filing of the judgment, we have already paid him the rest amount, the principal amount.
Paid,
already paid.
the principal amount, not the interest.
Not the interest.
Now the remaining is only the interest.
The interest part. That was a judgment on our admission. That's what.
How much according to your calculation it comes till now?
To my calculation, Lordship, for that I'm
If we calculate 3.5% from the date of till the filing, and then after filing 6%.
Lordship, that's what I'm saying. Since Lordship, the CPC says Lordship 6% per annum at most.
Okay.
That also in a commercial transaction. Since Lordship, that's what I'm saying. The fake of the case, how the loan money was taken from the private respondent. Had it been a commercial transaction, that would have been a different issue. And Lordship, had the money given from his account.
How much difference it is coming? As per your calculation at 6% from the very beginning, and 3.5% till the filing, and then after 6% after filing. What is the difference of amount?
Lordship,
otherwise you are ready to pay 6% as per the CPC.
Yes, I'm as part of CPC, Lordship.
From the very
Therefore,
beginning, 6%.
Calculation, Lordship.
So the difference is only 3.5% per month.
Per
for 3
month.
years.
That has to be per annum, Lordship.
It has to be per annum.
That also not 6%. 6% is also exorbitant, Lordship. That's what I'm saying.
6% is not probably exorbitant because in any other case also somewhere 7, 8, 9.
Lordship,
code also
CPC
used to
section
pass.
34 says that Lordship, where the transaction is a commercial transaction. That Lordship, the 6% is.
Sometimes it depends on how the agreement you enter into with the parties, and on what terms and conditions you accepted the loan. Yeah.
Lordship, I've been instructed from the from the date of filing, I'm ready to pay 6%, Lordship. From the date of filing of the suit, money suit, till the judgment.
No, what about the period from the beginning to till filing?
Lordship, if that would be like I've been instructed, if that would be 2 or 3% per annum, Lordship. Since Lordship, I have given in my written
No,
statement.
there the code has given per month. There.
Per month, Lordship. That's what,
Yeah.
Lordship, I'm agreed with
And you-
him.
But you are not ready to give even 6% for that.
Per month, Lordship,
Per year.
per year. That is the Lordship. That I have to take instruction, but I have been instruction as per the banking, as per the CPC, Lordship, they're ready to pay them. And Lordship, what the law says, Lordship, and the agreement that was a promissory note, Lordship, whether that promissory note can be accepted by the honorable court or not. So the head says the lordship that
No, if it is admitted one, then
even admitted lordship, what the section 23 of contract action, may I read lordship?
Yes.
Contract,
section
section 23
of
contract act 1874. Before that lordship, may I take to page 44 is the promissory note on the basis of which the learned court below had 44
page
44 lots 444 and 44A is the type copy lots.
okay.
May I read on?
Hmm.
I Sri D.K. Tongdok, that is the applicant of Rupa has taken an amount of
Page 44.
yes Lord 44A in my
Okay.
on loan basis of 3.5% per interest in the month of October 2019. The interest amount shall be counted from 2000. Today on so and so, it is agreed to pay the amount as that is 3 lakhs, 30 lakhs will be paid.
So the interest has to be counted from January.
Rupees 10 lakhs shall be paid to so and rupees 10 lakhs to so and so on 28/12 of 2020. The entire remaining amount with the agreed interest shall be paid to so and so by 31/5 of 2020. The interest amount shall be counted at the time of final payment. So this was the promissory note. And lordship, what the promissory note, on the basis of promissory note, can the honorable court, can this be admitted, lordship? Before that, lordship, even if lordship, what the contract act said, lordship? Whether this,
But it was admitted by the trial court.
yes, lordship, whether that can be admitted as per law or not, lordship, that is also has to be a question, lordship. Before that, lordship, section 23 of contract, what it says, lordship? Even if a two-party agreed themselves, which is not enforceable by law, can that be?
Which says?
Lordship, section 23 of Indian Contract Act.
Yes, please.
Section 23 says, what considered an object are lawful and what not. The consideration or object of agreement is lawful unless it is forbidden by law. That it is of such a nature that if permitted, it would defeat the provision of any law. Is the term invoke or implies injury to person or property of another, or the court is immoral or opposed to the public policy. In each of these cases, the consideration of object of agreement is said to be unlawful. Every agreement of which the object of consideration is unlawful is void. Lordship, even if there is an agreement between the parties saying, I'll pay you this such an amount, which is not enforceable by law, it's a void agreement, Lordship. Lordship, in illustration, I would like to read J, Lordship. J. It says, Your Honor, A.
Yes.
Who is B, Mukhtar, a promise to exercise his influence as such would be in favor of C, and C promised to pay 1,000 rupees to A. The agreement is void because it is immoral. Lordship, reading this in conjoint with section 34 of CPC. So Lordship, here even if
what section 34 CPC says?
Section 34 says about the interest, Lordship. Section 34 says, where
Yes.
Wherein insofar as a degree is for the payment of money, the court may in the degree order interest as such rate as the court deems reasonable to be paid on the principal sum adjust from the date of suit to the date of degree. In addition to any interest adjust on such principal sum of any period prior to institution of the suit, with further interest as such rate not exceeding 6% per annum as the court deemed reasonable on such principal sum from the date of degree to date of payment or to such earlier date as the court deems. It says also, provided that where the liability in relation to sum so adjust has been risen out of commercial transaction also. The rate of such interest further may exceed 6%, but shall not exceed the contractual rate of interest or where there is no contractual rate, the rate which money or land advance in bank in relation to commercial transaction. Lordship, here also it says it may exceed 6% in a commercial transaction. Lordship, that's what I'm saying, Lord. The fact of the case also, how the loan money was taken from the respondent. That also has to be seen by the Honorable Court. Lordship. Explain in the subsection, nationalized bank means a corresponding new bank. Lordship, as part the banking also, Lordship, 3.5% per month is an exorbitant. And Lordship, even if two parties have agreed that I'll pay 3.5%, that cannot be assigned by the Honorable Court, Lordship, since this is it's against the public policy, Lordship.
Where have you contended that it has to be from the date of the filing of suit, and you are not ready to pay for the period prior to the filing of the suit?
In my WS Lordship, there is no such any specific mean, but
Okay, this is submission, your submission of it.
Yes, Lordship, that's I've been instructed.
Otherwise, where have you stated that you are otherwise ready to pay 6% per annum? Have you stated?
That I have not stated. Last time since the I've been instructed, Lordship, like me.
Okay.
And Lordship, that's why in our WS also before the Honorable London Civil Judge Senior Division, there also, Lordship, in our WS we have not denied that we have not taken the loan amount, and we have said how the loan amount was taken, how that all, Lordship, on the
Let us see the ground for your prayer. Your prayer is to just a minute. Let us see your prayer for setting aside.
ground, Lordship.
No, just a prayer for setting aside and quashing the impugn order.
Yes, ma'am. The ground, Lordship, I have stated from page 10, Lordship, 16, paragraph 16 onwards.
Okay.
And it's till page 15, that is, and the prayer portion is the.
Okay, let us see the what other grounds you have taken. Any other special ground?
Lordship, we have right from Lordship, page 10, may I read on?
Page 10?
Yes, Lordship,
Okay,
the ground
please.
which we have taken.
Okay, please.
The one says, Lord, for the learned Civil Judge Senior Division committed manifest error of law apparent on face of the record entitling miscarriage of justice in passing the impugn judgment and degree that so and so. And second says, for the learned Senior Division failed to appreciate that on the written statement, the appellant, that is defendant, had partly admitted and partly denied the rest statement, admitted amount of rupees 1 crore and paid back the amount of 1 crore 9 lakhs only as and had denied the rest statement of plaintiff in the money suit. Meaning thereby, Lordship, we have denied the 3.5 in the promissory note also. But for the learned civil judge has failed to appreciate the fact that the appellant had vehemently objected the interest claimed by the respondent plaintiff. For the learned senior has failed to appreciate disposal of under 12 Rule 6 judgment of admission. The admission should be categorically unless the admission is clear, ambiguous, and unconditional. Discretion of courts should not be exercised to deny the valid right to contest the claim. For learned senior judge, senior division has passed the impugned judgment giving effect to a promissory note which can be considered only for a collateral purposes, and hence trial of the money suit is mandated. As such, the impugned judgment is in this moment. I would like to pause for a little moment on a promissory note. Lordship, the law is clear that a promissory note cannot be taken as a conclusive evidence. For that, a trial.
But trial was conducted in the instant case.
No trial was conducted. On admission, the judgment was passed, Lordship.
Oh,
That's what
only on
Lordship-
admission, no trial.
No trial. That's what Lordship I've been saying. On our WS, we have partly admitted, partly denied. That's what
You have, after filing WS,
Yes, Lordship. After filing
in
of
the WS, you have admitted.
I have admitted, Lordship. That's what I'm saying. I have admitted of taking 1 crore 70 lakhs, and I have paid already 1 crore 9 lakhs, and the remaining 61 lakhs is there, which I'm ready to pay as part this as part of the CPC, as part of the banking norms. That's what Lordship I've been saying.
Okay.
There was no trial, Lordship. And then
Okay, after this, let us see the written statement also, the relevant portion.
in our written statement, Lordship. Written statement is from page 56, Lordship. Page 56, our written statement, which is.
Just a minute, huh?
56. Before that, Lordship, since this is whether the honorable court on promissory note can give judgment or not. In regard to the Lordship, I have a judgment.
No, you said that it's on admission. Since if the promissory note has been admitted, you said that the order was passed on admission.
Yes, Lordship.
And you have now objection with regards to the interest.
Yes.
Okay, page. Just a minute.
Yes, from page 58, Lordship, that is in page, page 58, Lordship, written statement, this paragraph.
Page
58, 58. So our WS before the learned civil judge senior division. Lord.
58.
Yes, 58. Lord.
Yes.
Paragraph 1, Lordship. Yes. Paragraph number 1, the plain is a matter of fact as such, answering defendant does not give it necessity. Here was, with regard to statement made in paragraph 2 of the plain, the answering defendant partly admit and partly denies. The defendant being the chairman of Tukpen Village Council. Here
Where we have said that partly, admitted partly?
No.
In which paragraph? Para 2.
Para 2, Lordship.
Para 2, where? Admitted, okay, partly admitted. Paragraph 2.
Yes.
So paragraph 2 talks about the promissory note.
No, Lordship, it says about that the amount of 1 crore 70 lakhs was taken by.
Okay, which part is admitted? And which part is denied? Have you clarified anyone?
Lordship, we have said that's it, Lordship. We have only since Lordship we have admitted taking of amount. That is, Lordship, why a trial was necessary, Lordship. Because we have partly admitted they have filed before the honorable court claiming a amount of 3 crores 26 lakhs 80,000. That's what, Lordship, we have said partly admitted of taking a loan of 1 crore 70 lakhs and denied the rest, Lord.
So, relevant.
Lordship, the relevant is in that would be in their paragraph, they have five. Relevant will be three.
What is this, the table which you have shown in the written statement? For total amount 1 crore 90,000, no, sorry, 90 lakhs, or 9 lakh is
Paid to the, was already paid to them before filing of that
Already paid.
money suit. Lordship, in paragraph 3 also, with regard to that's where we have admitted lots. In regard to this statement in paragraph 3, 4, and 5, that was there. The answering defendant partly admit and partly deny. It is that since the plaintiff and defendant being a close associate, handing and taking of money was normal. As such, the defendant having financial issue and after having discussion with the plaintiff and Mr. Naresh Glow, the amount of that was 40 lakhs, 1 crore 30 lakhs was transferred to account of SVLMC to the defendant account. From account of that was also lordship here also the amount was never transferred from the account of respondent to the appellant. That was transferred from the account of SVLMC to the defendant account. But due to financial management of the defendant associate, the amount could not be paid to plaintiff on time. Be that as it may, defendant is not shying away to make the plaintiff from the day one as such that has given the promissory note to on his request. We have denied the interest, but lordship here also we have said the promissory note was given on his request. Lordship. And in lordship, in the rest of our
till today, your total payment is 1 crore 9 lakhs.
No, lordship, after the judgment, we have paid the principal amount.
Where have, after the judgment?
Yes, lordship.
Where have you stated?
Lordship, we have not stated, but the respondent, they also have admitted before this honorable court of opinion.
Okay, no.
The principal amount is not disputed any longer, lordship. Only now,
The interest part.
Only the interest part. That they also not denied. The principal amount has.
Decree amount was 61 lakhs. Hello, we have received 61 lakhs.
Okay.
The only issue for determination is as to whether 3.5% pre-suit interest
Okay.
as awarded by the London trial court is correct or not.
Okay.
That is the only issue
You
remaining.
have any authority? Citation?
Lordship, the citations, lordship, I said the on
Just let us see the decree first once, the relevant portion. Let us see. This is your contention, and then
degrees, page 24.
just a
lordship.
minute, huh? Page?
Page 24, lordship.
Just a minute, huh? Page 24.
Yes, lordship.
Okay, 61, just a minute. 61 lakhs you have received. Okay. Yes, any other authority to substantiate your claim that, okay, you have shown the CPC and the Contract Act, anything else?
And Lordship, since Lordship, that judgment or the admission was passed on the basis of promissory note, whether that promissory note can be admitted without going into trial. So Lordship, for that I have a judgment. It says, Lordship, a promissory note cannot be a conclusive evidence.
So now you are disputing the promissory note. That means.
Since Lordship, I have to dispute it, Lordship, but I'm saying the interest rate that cannot be
No,
passed.
no, because you have already paid the principal amount till date, admittedly. And then that shows that it is admitted only.
Yes, Lordship, that I admit from the day one I've been admitting. Lordship.
So now how can you again?
Lordship, I'm saying on the basis of promissory note where I have stated that whether 3.5 per person.
3.5 only.
Whether
Where
that
the
is
relevant portion?
permissible as par law or not. Lord. The CPC also says section 34 says that
Okay,
it is
where do
not.
we find this judgment, relevant portion?
You know, here also discuss whether a promissory note made payable. What's the
Para?
Lordship, para 6, that is page 2, Lordship.
This is Allahabad. Para?
Para Lordship 6 is said the question propounded by Munsif can be answered by separating. Is the promissory note in question forbidden by law, Lordship?
The question.
Yes, Lordship. Here also.
Honored by the Munsif can this be answered by this.
Lordship, that there is a portion, Lordship. I'll just go to the operative portion, Lordship, since not taking much time of the court, Lordship.
Okay.
Page 4 of that is paragraph 21, Lordship. Is the promissory note admissible in evidence, and if so, for what purpose and to what extent?
Para?
Para 21, Lordship.
21.
Yeah. Here also a promissory note was executed between the two. Is the
Where is the answer?
Answer would be Lordship. Lordship, that would be, I would say, that is paragraph 32 starting from Lordship. 32, 32, that is page 6.
32.
Yes, Lordship.
Yes.
Lordship, and the suit which has given rise to the reference was brought on a promissory note, the term of which need not to be produced in detail, but it was a promissory note payable on demand to the lender or the bearer or to cost. In answer, the definition of promissory note is given in section 4 of negotiable instrument, Lordship. If you go to negotiable instrument, I'm not going further down. It has been provided in section 1 that nothing in this act affects the Indian Paper Currency Act, section 25. Paragraph 33 says the Paper Currency Act now in force is Act 10 of 4923, section 25, of which provide no person in India shall draw, says no, except make or issue any bill of exchange, hundi, promissory note, or engagement for a payment of money payable to bearer or demand, or borrow or take up any sum of money on which the bill, hundis, and not payable to bearer on demand or any such person. Section 26 of the Act provided that making an instrument in contravention of the provision of Paper Act is an offense, and penalty has been imposed for the transgression. That is which is against the laws. And paragraph 36, the general provision of the Negotiable Instrument Act cannot be treated as an indication of an intention on the part of the legislature to legalize an instrument upon which an interdict has been placed by the intervention of a special statute. Against section 120 of negotiable instrument cannot be construed to include the pay of negotiable instrument payable to bearer under the head of the holder individual. The promissory note clearly contravenes the provision of section 25(10) of 1923. Again, under section 23 contract, every agreement which the object or consideration is unlawful is void. The promissory note, the not being the consideration of the object of an agreement to lender are being clearly forbidden by law, Lordship. It says clearly forbidden by law. I would hold that it's offense against the provision of section 25 of the Act of 1922. I would further hold that promissory note not being forbidden by law cannot form the basis of a suit, Lordship. Then paragraph 22 or 42, Lordship, the last. It says, Lordship, the order of court is the following reason to return to land. The promissory note in question is a form forbidden by law. The promissory note in question cannot form the basis of a suit.
Which para you said?
Paragraph 42, Lordship.
42, 42.
Yes, Lordship, the last page.
Yes.
The order of the court is that the following answer be returned to landed Lordship. The promissory note in question is in form of forbidden by law. The promissory note in question cannot form the basis of a suit. It clearly says, Lordship, a promissory note cannot be a form of suit. Even if it's a form of suit, Lordship, that has to be proved in a trial. In a straight way, jacket way formula, the learned civil judge has on promissory note, which is.
And here is the case where you have admitted the promissory note and paid also, paid back also the principal amount. The only question is, of course, the interest.
Lordship, for that only I've come to section 23 of the Contract Act. Lordship, it says even if two parties agree, which is contravenes against the law, the court cannot give assent to it, Lordship, which is against the public policy, Lordship. The section 34 of CPC says, Lordship, it's a 6% that also in a commercial transaction. Lordship, that's what I've been saying, how the money was loaned from the respondent, that is plaintiff in the lower court. So, Lordship, here it was not a commercial transaction. That was a friendly loan. That's also that account was also never transmitted from the account of the respondent to the appellant, Lordship. That was, we had taken his interest, Lordship, that I'm not arguing on that, but I'm saying loan amount, how the loan amount was taken from it. And Lordship, section 23 of Contract Act says, the Lordship, that has to be a public policy, which is even if two parties agree to do a interest which is against the public policy, that the court cannot give assent to it, Lordship. Lordship, here is it's a large judgment, but I'm just on section 23, I'm just quoting just a small paragraph, Lordship. This is also a Lordship based on section 23 of Contract Act. I'll just read, Lordship.
Yes.
Paragraph. The observation of Supreme Court in Manala Ketan 1972 SSC 42 paragraph may be quoted useful for the point of under. It is well established that a contract which involves in its full and doing of an act prohibited by statute is void. The legal max
that the contract which involves is fulfillment.
The legal maxim practice provertorum publico juri non derogatory means that a private agreement cannot alter the general law. Where a contract expressed or implied is expressly or by implication forbidden by statute, no court can lend it essence to give it to effect. That is what is contravention of provision of an act of a legislature cannot make the subject of an action. This is here also, Lordship, it has been discussed in elaborate section 23 of Contract Act, Lordship. Since here also, Lordship, under promissory note.
Where it has discussed section 23.
Yes, Lordship.
Where?
It is from paragraph, Lordship, 20, Lordship, 20, 21, 22. Lordship, it's from paragraph 4, 6, it's about a contract, Lordship. Paragraph.
Is all, you see, because you have admitted, only the thing is that whether you can, even if it is admitted, whether this 3.5%.
Yes, Lordship, that is our basically argument, Lordship.
Okay.
We have admitted.
Anything else?
No, Lordship. Okay.
Yes. So, this is the contract act says, and the CPC also says. So, against that, so, against that, do you have any? What is your submission?
My submission would be, my lord, since this is a judgment on admission, now they cannot raise those issues which they have not raised in the written statement. With regard to promissory note, my lord, there's absolutely no rebuttal in the written statement. In fact, they have admitted everything. Therefore,
No, in the written statement, just said partly admitted, partly denied. So what it says is that when they say partly admitted and partly denied regarding the promissory note also, then in the trial only it will be clarified that whether that can be allowed.
I will deal with that query from my lord.
Yes.
My lord, may kindly allow me to place
Mm, yes.
my lord, the only issue which remains for determination in my humble submission, understanding is that whether the 3.5% pre-suit interest
Yes.
with effect from 2019 till filing of the suit
Right.
is correct or not.
Mm.
In support of the impugned judgment and decree with regard to 3.5%, I would make my submissions on 2 grounds. Ma'am,
Yes.
needless to mention, there are 3 kinds of interest: pre-suit interest, interest pendency light.
Three kinds of?
interest.
Okay.
Pre-suit interest, interest pendency light, and future interest. The power to grant pendency
3
light-
kinds of interest. What are those?
Pre-suit interest, madam.
Yes, this is pre-suit interest.
Yes, madam.
Yeah, which we are in.
Madam. Now, with regard to the 2 other interests, that is interest pendency light and interest future interest, madam,
Hmm.
it is pure discretion of the court under section 34.
Hmm.
Whereas the power to grant pre-suit interest is totally dependent upon the terms and conditions of the contract. The power to award pre-suit interest is derived from the Indian Interest Act. Section 3 of the Indian Interest Act says that, my lord, may kindly have Indian Interest Act for a moment.
Please.
Section 3.
Yes.
Section 3. madam. Power of court to allow interest. In any proceeding for recovery of any debt or damages, or in any proceeding in which a claim for interest in respect of any debt or damages already paid is made, the court may, if it thinks fit, allow interest to the person entitled to the debt or damages, or to the person making such claim, as the case may be, at a rate not exceeding the current rate of interest for the whole or part of the following periods. That is to say, A, subclause A, this is with regard to pre-suit interest. If the proceeding relates to a debt payable by virtue of a written instrument at a certain time, then from the date when the debt is payable to the date of institution of proceeding. Now, with regard to that rate not exceeding current rate of interest, subsection 3 is an exception to this bar. Now, let me kindly have subsection 3. Nothing in this section shall apply in relation to. May I read?
Yes.
Nothing in this section shall apply in relation to any debt or damages upon which interest is payable as of right by virtue of any agreement. Therefore, my humble submission, my lord, since they have admitted the terms and conditions in the promissory note, the learned trial court has correctly awarded the pre-suit interest at a interest rate which was agreed between the parties and admitted by the appellant in the written statement. In support of the submission, my lord, may kindly allow me to place one authority of the Honorable Apex Court. 2011 1 HCC 790, madam, paragraph 13. 2011 1 HCC 790, paragraph 13. This is with regard to principle that the pre-suit interest will depend upon the terms and conditions in the contract between the parties.
Yes.
Paragraph 13. Section 34 of the Code of Civil Procedure empowers the court to award interest for the period from the date of suit to the date of decree and from the date of decree to the date of payment, where decree is for payment of money. Section 34 does not empower the court to award pre-suit interest. It is only the Indian Interest Act. The pre-suit interest would ordinarily depend on the contract, express or implied between the parties, or some statutory provision or mercantile usage. Therefore, my lord, in my humble submission, the pre-suit interest which has been awarded by the learned trial court is correct because there has been no rebuttal to the 3.5% interest rate as mentioned in the promissory note in the entire written statement. That is my first ground of argument, Lord, in support of the impugned judgment in decree.
Not review.
Sorry, brother.
Well, you said that,
Not rebuted. Not rebuted. That 3.5% interest.
not rebutted.
Not rebuted. Now,
Okay.
now, my lord, coming to the defense of the appellant in their written statement. In the entire written statement, my lord, they have not denied 3.5%. Rather, they have admitted, my lord. First, I would like to take, my lord, to the relevant paragraphs in the plaint where the respondent as plaintiff had claimed 3.5%. Paragraph 5, page number 30.
Oh,
Page number 30 of the appeal, my lord. Paragraph 5, this is the plaint.
30.
30.
Okay, this is a plain.
Plain. Starts from page 25, my lord. I'll read paragraph 5 at page 30.
Paragraph 5.
Paragraph 5.
Okay, yes.
Ma'am, the plaintiff was expecting that the defendant would return the loan amount by 31/12/2018, but there was no sign of returning the loan amount. The plaintiff waited for few days with expectation. When there was no sign of refunding, the plaintiff started contacting the defendant over the mobile numbers and even went to the residence of the defendant at Rupa, who repeatedly assured to return the loan amount, and such false assurance went on and on. Finally, on 10/12/2019, the defendant executed a promissory note in presence of Naresh Blow at Itanagar. The contents of the said promissory note dated 10/12/2019 2019 is reproduced below. Promissory note dated 10/12/20. I, Shri such and such of such and such, had taken an amount of rupees 1 crore 70 lakhs only on loan basis at the rate of 3.5% interest per month in the month of October 2018. The interest amount shall be counted from the month of January 2019. Now, paragraph 14, Melod, may kindly come to paragraph.
So it was taken on the October 2018,
18,
but the interest would be counted from since January 19.
January 19. That is
Okay.
my claim,
Okay, your claim is from since January 19.
January 19.
Hmm.
Now, Melod, may come to paragraph 14, page number 37. I'm reading this paragraph because in this paragraph I have claimed 3.5% interest with effect from January 2019.
So which one, which paragraph you said?
5 and now 14. I've read 5. Now, Melod, may come to paragraph 14, page 37. Name,
Yes, sir. Page 37.
page 37, paragraph 14. That the final loan account of Sri D.K. Thongdok Rupa as on 31/8/2022 is reproduced below. Loan amount taken in October 2018, 1 crore 70 lakhs. Total months counted from January 2019 to 31/8/2022, 44 months. Monthly interest at the rate of 3.5%. Now, my lord, may kindly come to their reply in the written statement. My lord, may kindly turn to page 58.
Page 58.
Page 58, paragraph 3. That with regard to statement made in paragraph number 3, 4, and 5 of the plain. 5 I have read. The answering defendant partly admit and partly denies it. Since the plaintiff and defendant being a close associate, handing and taking of money was normal norms. As such, the defendant having financial, page 58. Paragraph 3 onwards. That with regard to statement made in paragraph number 3, 4, and 5 of the plain, the answer
Yes, sir, we have seen that.
partly admit, since the plaintiff and defendant being close associate, handing and taking of money was normal norms. As such, defendant having financial issues and after having discussion with the plaintiff and Sri Naresh Gro, the amount of 40 lakhs and rupees 1 crore 30 lakh was transferred from the account of SVLMC to the defendant account. But due to financial mismanagement by the defendant's associates, the amount could not be repaid to the plaintiff on time. Be that as it may, the defendant is not shying away to make payment to the plaintiff from day one. As such, he has given promissory note to the plaintiff on his request. Now, my lord, may kindly come to paragraph 10 at page 61. Paragraph 10 is the corresponding reply to paragraph 14 of my plaint, which I have already read. Page 61, paragraph 10. That with regard to statement made in paragraph 14 of the plaint, the answering defendant partly admit and partly denies it. That the plaintiff having admitted in paragraph 14.6 that the part of payment made till the filing of intent suit to be rupees 1 crore 5 lakhs, but as per calculation of defendant, it is rupees 1 crore 9 lakhs, meaning thereby defendant payment made to the plaintiff cannot be ruled out. I would beg to reiterate my submission, my lord, that the claim of the plaintiff in plaint, that is 3.5% interest, has not been denied in the entire written statement. Rather, the appellant in their written statement has admitted
the promissory note and terms and conditions of the promissory note. Yeah, nowhere you have denied in the your entire written statement.
That's what I've said, partly admit, partly deny.
Okay, so but no specific, no specific denial. Okay, okay. Yes, please. Deal with that. My lord, please. Rules 3, 4, and 5 of Order 8 deals with the manner in which the assertment of the allegation of facts made in the plaint have to be traversed. And these rules also provides the consequences of non-traversal of the assertment of facts in the plaint. Lord, may kindly have CPC for a moment. Order 8, Order 8, Rule 3 onwards. 3, 4, and 5. Rule 3.
Denial
To be specific. Okay. It shall not be sufficient for a defendant in his written statement to deny generally the grounds alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. Now coming to Rule 4. Just a minute.
So 3 is denied to be specific.
Specific. Rule 4 deals with evasive denial, the effect of evasive denial.
Yes, evasive denial.
Where a defendant denies an allegation of fact in the plaint, he must not do so evasively, but answer the point of substance. Thus, if it is alleged that he has received a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received. And if any allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. Now, coming to Rule 5, which deals with specific denial. Every allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in of the defendant, shall be taken to be admitted except as against person under disability. Be provided that the court may in its discretion require any facts so admitted to be proved otherwise than by such admission. I have already taken my lord to the relevant paragraphs in the plaint and their corresponding reply to those assertment of facts in those paragraphs in the written statement. There's absolutely no denial. My lord, the effect of evasive denial is amounting to admission, because any denial of fact has to be specific, not that partly admitted, partly denied. Such denial would amount to admission. In support of my submission, my lord may allow me to place one judgment of the Honorable Apex Court. Paragraph 2013 2 SCC 606, paragraphs 23 and 24. Paragraph 23 and 24. May I read?
23, 24.
Yes,
Yes.
the said aspect can be looked from another angle. Rules 3, 4, and 5 of the Order 8 form an integral code dealing with the manner in which allegations of fact in the plaint should be traversed, and legal consequences following from is not non-compliance. It is obligatory on part of the defendant to specifically deal with each allegation in the plaint
And when the defendant denies any such fact, he must not do so evasively, but answer the point of substance. It is clearly postulated therein that it shall not be sufficient for a defendant to deny generally the grounds alleged by the plaintiff, but he must be specific with each allegation of fact. Paragraph 24. Rule 4 stipulates that a defendant must not evasively answer the point of substance. It is alleged that if he receives a certain sum of money, it shall not be sufficient to deny that he received that particular amount, but he must deny that he received that sum or any part thereof, or else set out how much he received, and that if an allegation is made with diverse circumstances, it shall not be sufficient to deny it along with those circumstances. Rule 5 deals with specific denial and clearly lays down that every allegation of fact in plain, if not denied specifically or by necessary implication or stated to be not admitted in the pleadings of the defendant, shall be taken to be admitted against him. Therefore, my lord, in my humble submission, my lord, firstly, the impugned judgment and decree to the effect of awarding 3.5% in pre-suit interest is correct because it is based on the terms and conditions of a promissory note. Second, my lord, since there is no denial in the entire written statement with regard to 3.5% interest and also the promissory note, therefore, the learned trial court has correctly awarded 3.5% on admission. Now, when it comes to, my lord, equitable jurisdiction, since my learned friend has raised an issue that it is against public policy, what he is seeking is equitable jurisdiction of what he's seeking is to invoke the equitable jurisdiction of this court. But in my humble submission, equitable jurisdiction cannot be invoked, divorce the statutory provisions. Since the statutory provisions, that is Indian Interest Act, subsection 3 carves out an exception to subsection 1 that the interest, pre-suit interest would be dependent upon the terms and conditions of the contract. Therefore, equitable jurisdiction in this case cannot be invoked against that statutory provision. In support of that submission, I may be allowed to place another judgment. Two 2007 8 SCC, page number 600. Paragraphs 26, 27, and 28. Merit 26, 26, 27, and 28. Yes. 26. In England, the Court of Equity exercises jurisdiction in equity. The courts of India do not possess any such exclusive jurisdiction. The courts in India exercise jurisdiction both in equity as well as law, but exercise of equity jurisdiction is always subject to the provisions of law. If exercise of equity jurisdiction would violate the express provision contained in law, the same cannot be done. Equity jurisdiction can be exercised only when no law operates in the field. A court of law cannot exercise its discretionary jurisdiction beyond the statutory jurisdiction. Its discretion must be exercised in terms of the existing statute. In Samsu Suhara Devi versus G. Alex, this court, while dealing with a matter relating to grant of compensation by High Court under Section 21 of the Specific Relief Act, in addition to the relief of specific performance in the absence of prayer made to that effect, either in the plan or amending the same at a later stage of the proceeding to include the relief of compensation in addition to the relief of specific performance observed. Grant of a specific relief in teeth of express provision of statute to the contrary is not permissible. On equitable consideration, court cannot ignore or overlook the provisions of statute. Equity must yield to law.
since there's a specific provision under the Indian Interest Act, equitable jurisdiction cannot be invoked, divorce that law. With that, I conclude my argument.
More submission also.
Yes, what is that?
Now, in regard to the interest of 1978, which my friend has shown, Lordship, here also it says section 5 of it says, Lord, section 34 of the civil procedure 1908 to apply. Lordship, it says nothing in this act shall affect the provision of section 34 of the Code of Civil Procedure. This also says that on the section 34 of Civil Code will
34 deals with interest, pendency right, and future interest, not pre-suit interest.
That is, it comes under when the interest is passed by the learned civil judge, it's always on section 34 of CPC. Lordship. And Lordship, on admission also, since Lordship, I'm not on the admission basis, but Lordship, I have been a judgment on admission. It says, Lordship, that has to be clear and ambiguous, Lordship. Yeah, just for your reference, Lordship. Order 12, Rule 6, Lordship. Since Lordship, I've been saying partly admit, partly deny. That partly admit and partly deny. That has to be on when a matter is before a trial court. Then we can make out which was admitted, which was denied, Lordship.
Yeah, para?
Para, just para 10, Lordship. Very low. It is true. This is a 2011 15 SCC 237.
Yes.
It is true the judgment can be given on an admission contained in the minutes of the meeting, but the admission should be categorical. It should be conscious and deliberate act on the party making showing an intention to bound by Order 12 Rule 6 being an enabling provision. It is neither mandatory nor preemptory but discretionary. The court on examination of fact and circumstance has to exercise its judicial discretion, keeping in mind that the judgment on admission is a judgment without trial which permanently denies and remedy to defendant by way of appeal or merits. Therefore, unless the admission is clear, unambiguous, and unconditional, the discretion of court should not be exercised to deny the valuable right of defendant to contest the claim. In short, the discretion should be used only when there is a clear admission which can be acted upon. Since Lordship in our WS, we have said Lordship partly admit, partly denied, and that's what I've been saying. Lordship, we have admitted of taking a loan of 1 crore 70 lakhs, and we have admitted that we have paid 1 crore 9 lakhs, and only the principal amount is 61 lakhs that which we are ready to pay. So in Lordship, rest we have denied. BS that we will Lordship that since Lordship I have been able to show this court that the contract of section 23. Even if two parties agree, which is avoidable, which is the host which is void contract law, that cannot, the honorable court should not give assent to it, Lordship. With this, Lordship, I'll conclude my submission.
Mr. V. Jamo, Land Council for the appellant. I've also heard Mr. R.L. Thungan, Land Council for the respondents. Starting. Hearing concluded, judgment is up. Your paper. Two papers.